Hey everybody, if anybody's here, this is kind of a spontaneous live. I was just going to update my interview reminder for tonight for my Sherilyn Cadle interview, and I saw that Lori Vallow's back in court in 20 minutes, guys, the one against Rob Wood. So it should be coming on in about 20 minutes. I'm going to live stream it and maybe chat about it a little bit after, and then I want to get ready for the interview tonight because I still have to put in some questions for tonight. But yeah, it should be coming on shortly. I guess the judge, I didn't even know they were in court this week, guys. I guess the judge dismissed Rod Wood's request to keep it private, and so it's going to be public, this hearing. So I don't know if this is just going to be like a setup for something bigger or what is going to happen in this court hearing, but we'll see. Hey, Katie, Ketcha, Lowry, Jay Bird. I threw this together so quick, so my thumbnails just like thrown together. I was setting up my new reminder for my Sherilyn interview tonight because a lot of people maybe were having trouble finding it because I put it up like 2 weeks ago. So I have a new one up for tonight, but I ran into this video where it's showing that Lori is back in court today, guys. So hopefully, let me see how much time. Hold on a second. It had a time of when it was going. Let me see what it says. So it looks like in 20 minutes. She's supposed to start at 11. So it might start early, but I figure I'd come on and talk to you guys for a little bit. It's a hearing against Rob Wood, I guess, guys. Hey, Tammy, Little Miss, Jen, Kristen. Are you guys been following the Vallow case? Because this is it's going to be the Lori Vallow hearing against Rob Wood. I don't know if you guys are familiar. Sometimes I'm not sure if you guys are, because I know some people are just following the Watts, some people are following the Vallow, but it'll be interesting. Hey, Scott and Choir. We'll see. I don't know if Lori will actually be in court. I know I caught when I was trying to put this together because I didn't know that they were in court earlier this week. Well, not them, but their lawyers. So I didn't get to watch that yet because I wanted to hurry up and make sure I had this set up to do the one for today. So I missed the one. It was either Monday or Tuesday with their lawyers. Did you guys watch that one? Hey, Jennifer Good, Love and Coco, Jay Bird, Petra Vaughn, Tammy. Did she? I don't know. I'm not sure. I am so behind on this. I didn't even know this all was going on. Oh, thanks, Weber. Yeah, I don't know if she missed one. I know I watched like a couple minutes of the one. It was either from Monday or Tuesday. It had Rob Wood and Mark Means were there, but you didn't like chat Pryor wasn't even there. But yeah, Lori wasn't there. I don't know. She missed it. Is that what happened? Well, I know the hearing I'm talking about, it basically said, because Rob was trying to keep everything private where it wasn't going to be public. Well, what is the word for it? I don't even know what the word for it is, but basically they came to the conclusion that no, they're going to make it public. And that's what today's supposed to be, I guess. I don't know if there's going to be more or they're going to take care of it all today. I don't know how long it's going to be. I'm not sure because I didn't get to watch the first one. I didn't have time. I was nervous I was going to miss the hearing because sometimes they start early and I wanted to get a thumbnail together. I put that thumbnail together so quick. Oh, are you talking about my picture of me and Zeke? Oh, Miss P, okay. Let me see how long we got here. Hold on a second. Okay, 17 minutes. All right, guys. So you guys ready for the interview tonight, though? That'll be very interesting. With Sherilyn Cadle. I just made a new reminder, so let me know. Hopefully you guys will be able to find it. Hey, Jaber, Katie. Page Q. Is Page Q here? R.A. What's going on? You're funny. Oh, SKVO. Katie Lynn. Oh, but did she miss it or she just didn't have to go? Well, do you think she'll be here today, Katie Lynn? Or is it just going to be the judges? I feel like I'm really behind on this. Well, because all these little prior, little court hearings, I'm waiting for the big trial. That's going to be, I'll be watching it every day. Hopefully, watch it be the same time as if Chris really does get a trial. Watch it be the same time. No, I bet you if he gets a trial, that'll probably be set back. How long? Like a year or two for them to prepare, maybe? I don't know. I know, I'm excited too, Andrea. I really am. I'm going to have Jill up there with me. So she was on, she was up on panel the one time when Kim came up. Remember, Kim was in chat and Kim came on panel. Jill, she was the one with me that night. She's going to be with me tonight because it's so much easier to have like at least one other person. So like when one person's maybe asking questions, the other person can look at chat and back and forth, we could take turns and stuff. So yeah, she'll be there with me tonight. So that'll be good. Wait, what? Mexi and then Zavgirl. Wait, what do you mean, little miss? Mexi and then Zav with Kato. I'm not sure what you mean by that. Man, I hope I don't. Hold on a second. What? Wait, what do you mean? I'm confused what that means. Mexi and then Zav, Oh wait, is Mexi coming on tonight with something? I didn't even know. Hold on, let me see. Make sure this hearing didn't start yet. No, not yet. Okay, I'm nervous. I have it shared, so I think we'll be able to hear it when it comes on because it's already like shared. So I don't think. Hopefully, it'll make us. If it does start, then we won't miss it because we'll hear him. But I'm going to keep checking. I suppose it started at 11. But I know a lot of the times, most of the times it starts early, but then the last time it actually started late. That was like the only time it started late. And most of the hearings always started like at least a few minutes early, if not like 10, 15 minutes early. Yeah, loving Coco. I don't know. I'm nervous. I don't even know what to expect on this. I hope Rob well, either way, if Rob does get disqualified or whatever you call it, then I'm sure whoever they get will be prepared, Hopefully they'll prepare him good enough. But that'll feel so bad because that's not right. But I guess we don't know what the situation is. I feel like if they had their lawyers with them, then there shouldn't be an issue. And they should be in court, right? Shouldn't Summer and Zulema be in court because it was their claims, right? So that's what I don't know what today's going to be. Is it just going to be like the first part and then there's going to be like a trial type situation? Or is it all going to be taken care of today? I don't really know. Hey, Miss My Adventures. So Lori, remember when Mark Means and Lori made those claims against Rob Wood? They said basically he met with Summer, which is Lori's sister, and Zulema, which is the girl that Alex married. Alex is Lori's brother. And they said basically that what did they even claim? It was stupid. He said it's all recorded. The interview, I forget how they worded it, but basically he crossed some line interviewing him when he basically said the first interview was just kind of like an introduction, and he said he wasn't even at the interrogation part interview, and the part that he was at, like the introduction, which their lawyers called him to meet, from what the affidavit said, he meets with them. He said they both had their freaking lawyer with them. So if he crossed any line or took it too far, why wouldn't they object? They were there with the two people that are making these claims. It's a bunch of crap. So I don't know who the judge is going to be. Is it going to be Mallard? I know, I hope I'm remembering the name right. Mallard, right? She was the one I saw earlier. It's either Monday or Tuesday. She was the one that was there for that. I think her name's Mallard, if I'm remembering right. Man, it's been so long since I've looked into this case. But there really hasn't been much going on, I'm kind of just waiting for the trial. And then there's a little here and there, a little drama, that Lori's bringing up. Did I tell you I tried to contact Lori. What is it called? Now I forget. Misbehaved is one that told me about. What is it called? It's this app, and basically I wrote her, and you have to put money on there to even write her. So I had to put money on because I wanted to write her. I just wanted to like pretend, Well, I don't know what I wanted to do. I was just being nice. What did I even say? I guess I was just asking about like the Bible because we know she's so passionate about the Bible, but I wanted to get her to at least start talking to me so she wouldn't immediately just like cut me off. Well, she has a choice where she could block me. She didn't block me. So I wrote her like a message. She never did block me, but she didn't respond. So I don't know what that means. But I just wanted to see if she would talk to me. But yeah, I don't think she's going to. I bet you she won't. I bet you after the trial, if she's in prison for a long time, then, when the trial's over, then she might start talking to people when she has nothing to lose. But right now, her lawyers probably are like, don't talk to people. Who knows? But I tried. I was just curious to see. You guys probably think I'm silly. Wait, what's going on? Hey, Marky Mamba, Jen, Peloria Kush. Probably. I believe that. Are you talking about, wait, who are you talking about? Means? I believe it because you could tell he's very inexperienced. I would definitely believe that he never worked a felony case. I don't know. I haven't really looked into it, but he doesn't seem like the type that has any experience in this. And that's why he's trying to like do anything before the trial starts. And that's why he probably wanted the trial to be combined because prior he's tough. Like you could tell he has experience. So yeah. I don't know, Paige. I don't know the gossip going around with the Vallow case. I don't know. Did that happen recently? She had contact with a publisher. Remember Chad talked about that, about writing a book. Well, because he's an author, but he mentioned it. Remember how did that come about? That was like months ago. He said something. Was that before he was in jail? I forget how that came about, but he mentioned something about how he's working on a book or something. Do you guys remember that? All right, let me see where we're at with this here. 8 minutes. I'm kind of nervous because I don't even know what to expect. Oh, they're trying to get rid of Lori. So right now, this one's going to be the prosecutors who they're trying to get rid of right now. But you're saying that they're trying to get rid of Mark Means too? Because this hearing now is for getting rid of the prosecutor, not her lawyer. But maybe you're talking about something else that she is. I didn't hear anything about that. Huh. Well, I think I am going to go on. I still have to respond to Left Undone. And maybe she'll update me on all the little gossip because I've been so into the Watts that I got so sidetracked. But I definitely am still interested in this case. Man, I've been following it since the beginning. It's crazy. It's one of the pretty crazier cases. All the people in it. It's wow. If some of you guys haven't been following it, go check it out. This is like so much stuff happened around these two people. It's crazy. Come on, I just wanted to start. Because then after this, I want to go take a shower and get ready for the interview with Sherilyn. Do you think this is going to be like a quick thing, or is this going to be, hey, K-Clo? It's a very big story. I don't understand this summer stuff. Yeah, I don't know. I mean, I guess, hold on a second. What does that say? still don't understand the summer stuff. What do you mean, like her sister's stuff? Hey, Matt, what's up? Matt in the house, guys. Dennis, what's up? Kids were found. Oh, wait, Chad's lawyer bought his... What? Pryor? Bought his property assuming one kid were found. Anyone know? No, I didn't hear nothing about that. I thought his kids were living there. Huh. Wow. I don't know. I didn't hear about that. I'll have to see. But I haven't been following it as close as I was at the beginning, so maybe that happened. But as last I heard that what was his daughter or his son moved in there. Oh, okay. Really? Wait. Where can I find this information? Whoa. There has been some stuff. What? So is he renting it out to his kids? Chad's kids? They don't live there anymore? Wow. I did not know that. Man, I need to catch up on some of this stuff. Whoa. Let's see. We have 4, so it should be starting any minute. That's crazy. Yeah, I'm going to look into that. I didn't know that. Wonder if he's renting it out to his daughter or son, or is he living there? Or if I was Chad's kids, I don't think I would. I definitely would not want to live there. What happened there? There's no way I could live there. I couldn't do it. I really couldn't. This is one of the first cases I've been with. Oh, yeah? It's hard being in the UK, but this case has been updated so well for once that you're constantly... Yeah. It definitely is all over the media and stuff. It definitely is kind of different as far as how Well, because it's still open, I guess. I mean, as far as they haven't even been to trial yet. And there is a trial with the Watts. He took the plea deal and it just shut everything down. So I guess it was handled different because it was a whole different case of how it all happened. All right, hold on a second, guys. Let me see what's going on. Oh, man. All right, let me see. 3 minutes. Okay. I'm anxious. I just wanted to start. I'm really anxious, guys, for some reason. Saying 3 minutes, but yeah, I guess there's a recording of... Are you talking about Rob Wood? Of when he was talking to Zulema and Summer. And I don't know if they're going to play it for us. I mean, I think we're going to be able to hear everything. I don't know if it's going to be today because there might be more than one hearing. I don't know how it's set up. But they basically said that he was requesting for it to be private and they said no. I mean, it's going to be public. So I think we're going to be able to hear it, guys. Oh, thanks, Eras. Wait, are you saying it's not on right now? Well, what is the court? Oh, her misdemeanor. I thought I was like, wait a minute. What are we waiting for then? Yeah, I saw that. There's 2 different ones. They're all pushed back to July, August, late August. It's crazy how they keep switching it, like pushing it back a little bit at a time. What can I watch live? It is. That's what we're gonna watch this live. It's just not on yet. It hasn't happened yet. We're waiting for it to start. That's what's going on. It should be starting in a few minutes. To be honest. Hold on. Just give me a minute. Let me go check. And Zeke's good. I saw somebody asked about Zeke. Hold on, I don't see chat right now because I'm checking on something. But I saw somebody ask about Zeke, and Zeke is really good. He's getting his hair cut today. Maybe I'll show you tonight with his new little haircut. He's getting it at noon, I think. Yeah, well, what time is it? 11. He'll have it done before the interview with Cadel, so maybe I'll show it. Hold on, guys. Give me a minute. I might be out for 1 second because it should be starting. I don't want to miss it. Just give me 1 minute. Come on, where are you? Huh. Just 1 minute, guys. I'm waiting. I don't want to leave the other screen because when it starts, you know how they just jump right into it, and I don't want to miss it. It's 11 right now, so it should be starting any minute. Come on. I just want it to start. So I don't have to worry about. I'm like nervous because I don't want to miss any of it. I guess. I mean, even if I was behind a couple minutes, but okay. No. Shoot, it hasn't started yet. What the heck? We're running a little late. I hope Lori's there today. I can't see the chat right at the minute until because I want to wait and stay on this page until it starts so I could hurry up but I can still talk to you. So what was I saying? Yeah, I hope Lori's there. I don't know. She wasn't there at the hearing either. It was Monday or Tuesday this week. I know she wasn't there, but man, this is the second time. At the first hearings were always early, and then these last two, well, not the one this week because I didn't see it, but the last two that I live stream were late for some reason. I like it when they're early. Come on, start. All right, I'll come back over to chat. Oh, maybe I should just wait here. Anyway, come on. You could probably hear Zeke barking, huh? Oh, he was a bad one yesterday. I slept with him last night, and oh my gosh. He slept pretty good for the first half of the night, and then the last half, he was antsy, and he kept getting down, and yeah, he was about like 4 or 5 in the morning, he started getting all antsy. I don't know, guys. I want to see the chat, but now I'm over waiting, and I can't see you guys, but when is this going to start? Come on. Well, let me see what you guys are doing over here. I don't know what's taking so long. Oh, wait, Weber, congrats on remission breast cancer. Oh, wow, Weber. I didn't even know. So it's in remission? Awesome. How are you feeling? Heidi. Farmers? Come on. Sorry, I keep going back and checking. Let's see. Oh, Misbehaved, what's up? I was just talking about you for a minute. Have you been, I know you Misbehaved, you're getting into the Watts case now, but are you still following the Vallow case as close as you were at the beginning? Because there's news that everybody's telling me in chat, like different things. Was like, man, I didn't even hear about all this gossip, like prior buying Chad's house. Did you know about that? I had no idea. To pay for like legal fees. So what the heck did Chad freaking spend that $450,000 or what was it? Like 400 and some thousand that he got from the life insurance. And what the heck? Where's Tammy's justice? When are they going to find out and release the autopsy stuff? Are they just waiting until after this trial just to wait? I don't know. Because you know they have the result by now. It's been, oh my gosh, let's see, that was December. So it's been about a year. It's been a whole year since they exhumed her body. There's no way that they don't have the result. So I wonder if they're just waiting to see how this trial goes before they make these charges. Not that they're not going to make them if they found something, but maybe they're waiting to charge until, I don't know what they're doing. Maybe I should start looking into this case a little bit deeper again. They're holding out on it. Yeah, I've been hearing about that murder charges coming, and her getting charged for Charles's, what'd they say, 4 to 6 months, and that was about 4 to 6 months ago. That the charges against Lori for Charles's murder, we haven't seen anything like that yet. It's like, when are we going to see? I think that was over 4 months ago, right? Maybe it hasn't hit the 6 month since they released that, but it's definitely hit the 4 months, I would say. Come on. I want this to start already. So you're saying they're holding off on Misbehaved. Are you saying they're holding off on him buying it, or? Oh, you don't think it will happen, Misbehaved? Why is it? Why don't you think? Why did they say that then? Why did law enforcement say 4 to 6 months? No, I don't think so, Palora. Not that I've seen, but who's been following this really close recently? Have the Daples actually came out and said anything? Come on. Okay, I'm getting really antsy. I'm getting very antsy. Okay. Duality. Hey, Duality. Yeah, because we know that Lori had a bunch of burner phones, remember? Who said something? Was it her friend, is it April, if I'm remembering right? Wasn't that her friend's name in Colorado, or in Hawaii? April, I think, said, when Tylee was with her, she said something like, Mom, you look like a drug dealer or something with all those burner phones. Something like that was said, I think. All right, come on, people. I don't know what's taking them so long, guys. Insightful. Hold on a second. All right. I don't know, guys. They're taking their good old time. Oh, it did? KTV? Hold on. Let me see. I could just stream it from there if it did. I didn't know. KTV.com. Did it really start? Okay, hold on, guys. If that's true, I'll just stream it from there. Yeah, you're right. Shoot, hold on, guys. Hold on. I'm going to just stream it from there because mine's not working. Hold on, guys. Give me a minute. Just give me 1 minute. Sorry. What the heck? I'm kind of upset that... Oh, well. Let's see if it's working. You said on KDV.com, right? Oh, no. Hold on. All right, where's it at?
An APY as long as you continue to meet qualifications.
Is this
so
it?
get earning.
The quality of life here is exceptional.
I was just kind of interested to go somewhere where I could be more
Wait, where
outdoorsy.
is
We're
it?
trying to move up here for a better life.
We make all of these different lists. So
hold on. Let me try it again. I see I was on the actual other thing, but hey, if that's... Hold on.
That isn't enough. Your account will continue to earn 2.5% APY as long as you continue to meet qualifications. So, get earning.
Attend the hearing per decision to not attend the hearing today. All right, thanks, counsel.
Yes.
All right, thanks, counsel. On these
Oh, wait,
motions,
hold
and I'll just
on.
ask both on these motions, and I'll just ask.
Oh my God, hold on, guys. It's playing both of them. Oh my God. You guys just bear with me. We'll rewind it. I'm sorry. Why is it doing this? It's because I'm nervous now because I'm trying to get it. Just hold on. So we're missing some of it. Well, where I was at was not even playing yet. Freaking mad. I didn't want to have to do it from a website like this, but I don't know. I'm desperate right now. There.
An accident happens in a
Why does
split
it keep
second.
doing
The
that?
aftermath can affect the
No.
lives of every loved one involved. Elk and Elk know.
No, that's not the right one. It's this one.
Of course, subject to cross-examination, I would then allow Mr. Means to put on his case in terms of arguing the motion.
Oh, let me do the big
After
screen.
that, my intent would be to...
I'm going to their YouTube page. You guys are probably already gone. I'm sorry. There, that's it. Okay, I got it now. All right, I got it now. I'm sorry, guys. Oh, it's all. I guess we'll just do it on their YouTube. Gosh darn it, I didn't want to do it like this, but you guys are all waiting, and my page...
In terms of submitting evidence where we are doing...
Let's back up, okay? We'll do it from the beginning. So we won't miss any. Oh, it did just start not that long ago. Okay.
The go live button for streaming.
All right, good morning, everyone. This is Fremont County cases CR 22-2025, State versus Chad Daybell, and Fremont County case CR 22-2838, State versus Lori Vallow. This is the time scheduled for a hearing on the defendant's motions to disqualify the prosecuting attorney. Those were both filed on December 15th. State filed its objection a day later on December 16th. Representing the state of Idaho in this case, let's see, Mr. Evans, are you going to be arguing the motion today or the opposition to the motion?
I am, Your Honor.
Okay, Troy Evans for state of Idaho on behalf of Special Prosecuting Attorney Madison County Prosecuting Attorney's Office. Representing Mr. Daybell is Attorney John Pryor. Mr. Pryor, can you hear me okay?
Yes, Your Honor, I can. Thank you.
All right, thank you. And then representing Ms. Vallow's Attorney Mark Means. Mr. Means, can you hear me okay?
I can, Your Honor. Thank you.
All right, thank you. Counsel, pursuant to the Idaho Supreme Court's most recent order regarding our court operations during the COVID-19 pandemic, we're conducting this hearing by Zoom. The hearing is being recorded on the Zoom software. It's also being recorded on our FTR system out of Fremont County, and it's also being reported by the court reporter. In addition, in order to allow access by the public to this hearing and help mitigate the spread of COVID-19, we are live streaming this hearing on the court's YouTube channel. Because we have a court reporter for this hearing, counsel, I would also make sure to ask you to refrain from speaking over one another so that we can make sure to take an accurate record of these proceedings. This hearing today will take place, as I mentioned, over Zoom. I would note, I'll address Mr. Pryor and Mr. Means. Your clients are not here present. Obviously, they do have the right to attend this hearing. I've been advised that each of them have chosen not to attend this hearing, although arrangements were provided for them to do so. Let me first ask you on that, Mr. Pryor. Have you spoken to your client directly about his right to appear at this hearing?
Yes, Your Honor.
And was it his intention to not appear today?
That is correct, Your Honor.
All right, thank you, Mr. Pryor. Mr. Means, I'll ask you the same thing. Did you speak to your client about her right to attend the hearing today?
I did, Your Honor.
And was it her decision to not attend the hearing today?
Correct, Your Honor. Yes.
All right, thanks, counsel. On these motions, then I'll just ask both Mr. Pryor and Mr. Means have filed individual motions. They cover a lot of the same issues, or maybe all the same issues. Are the parties both ready to proceed at this time?
I am, Your Honor.
Yes, Your Honor.
All right, and Mr. Evans, is the state ready to proceed this morning?
Yes.
Thank you. As I mentioned, each defendant has filed a motion to disqualify the prosecuting attorney, and the state filed an objection. I've reviewed those filings as well as the proposed witness and exhibit list that I've received from defense counsel. Pursuant to the court's previous December 17th and December 21st orders, some of those filings were filed under seal. I also received the stipulation for admission of certain exhibits that was filed yesterday. In terms of the procedure of this hearing, my intent would be to first allow Mr. Pryor to call his witnesses and present any evidence, of course, subject to cross-examination. I would then allow Mr. Means to put on his case in terms of arguing the motion. After that, my intent would be to have the state argue in response after both the defendants have presented their motions. And then finally, if there's any request for rebuttal argument after the state goes, then I would consider that. So, counsel, does that make sense in terms of the order of conducting this hearing today?
It does, Your Honor.
Yes.
Okay, thank you. In terms of submitting evidence, where we are doing this remotely, of course, we have to go through the process to get it admitted in the hearing and offered as if it were an in-person court hearing. If we run into any kind of technical difficulties, I guess everyone be patient. We've got support here to help us work through any of those issues to make sure any exhibits or other evidence are properly submitted for the hearing. But don't think that we're under any kind of intense time pressure or anything. If we need to take a moment to sort through issues regarding those technical aspects, I understand there are issues that come up frequently as we do things remote. So with that in mind, then, let's go ahead and get started on the hearing. As I mentioned, Mr. Pryor, I'll allow you to proceed first with your motion to disqualify. If you'd like to call your first witness or make any opening statement, you can do that.
Judge, prior to calling any witnesses, my understanding is that all of the parties have agreed and have stipulated by signed stipulation presented to the court that the transcript of the recording and the recording itself may be entered as an exhibit in this case. So I would respectfully ask the court at this time to have the transcript as Exhibit 1, the recording as Exhibit 2, marked and admitted as an exhibit in this particular, as exhibits, excuse me, in this particular case. And I understand that all of the parties have stipulated, so I do not anticipate any objection.
All right, so I did receive the stipulation, and we will mark then the transcript. And that is, to be clear, the transcript prepared by Nagley Reporting that was submitted by the court of a recording made on Thursday, October 1st, 2020. And by stipulation of the parties, then that will be marked as Exhibit 1 and entered. And then the recording will be, obviously there's no physical exhibit, but there is a file that would be the audio recording that will be Exhibit number 2. And it is also admitted by the previously submitted stipulation of the parties. All right, Mr. Pryor.
Yes, Judge. Judge, at this time, we would seek the publication of Exhibit number 2 and have it broadcast.
Very well. So Mr. Pryor, typically if you're the one offering or publishing it, then you would play that recording from your destination, and then it would be broadcast over Zoom and on the live stream.
Right. And Judge, my understanding, and Mr. Means and I spoke earlier today, that he has the recording and he's prepared to play that. I would ask Mr. Means to do that.
Okay.
Your Honor, I can do that. And a question I have for the court is, I believe the first witness that Mr. Pryor intends to call is Attorney Garrett Smith. He is the one who created the recording and provided it to counsel. Given the Zoom nature of this, he's in the waiting room to join the meeting. I think it would make a lot of sense for any kind of questions of what's been alleged by the prosecution as far as editing or deleting or altering of this recording, that Mr. Smith would be allowed to listen to the recording being played.
All right, in terms of that request, if we were to do that, Mr. Means, then I would think he would need to be actually brought into the hearing as if he were called as a witness and placed under oath before he were admitted for any other purpose. So
Agreed.
Wish to do that at this time. And Mr. Pryor, you're the one really proceeding here, but do you wish to have Mr. Smith brought in and placed under oath for future?
Yes, Judge.
Okay. All right, Madam Clerk, if you would admit Garrett Smith, the witness, and then once you've established that he's here, let's go ahead and place him under oath. Mr. Smith, this is Judge Boyce. Can you hear me okay?
Yes, Judge.
All right, good morning. You've been called as a witness in this hearing. I'm going to ask you raise your right hand, and I'll ask Madam Clerk to administer the oath, please.
Do you solemnly swear or affirm that the testimony you're about to give in the cause now pending will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right, Mr. Pryor, you can proceed.
Mr. Smith, will you state your name, spell your last name for the record for me, please, sir?
Garrett Smith, S-M-I-T-H.
Mr. Smith, how are you employed, sir?
I'm an attorney.
Okay, and out of what jurisdiction, sir?
Arizona.
Okay. Do you know the name Summer Shiflett?
Yes.
Okay. Do you know the name Zuluma Pastenes?
Yes.
How do you know them?
They're my clients.
Okay. Did you have an occasion to have a meeting with Mr. Rob Wood sometime in October?
Yes.
As a part of that meeting, did you advise Mr. Wood prior to the meeting that you would be recording that conversation and meeting?
I don't know if I said it like, you know, that I was going to be, you know, having a recorder on the table, but that, you know, that there would be concern for what my clients were testifying about in future purposes for, if they were to testify in the future, to be consistent with what they were testifying about. He told me they were going to be recording it, obviously, because it was a police investigation. So, you know, specifically, I don't remember if I told him that I was going to record that or not. But I mean, there was discussion about it, but I don't know that I came out and said, well, I'll be making my own recordings of that interview. I don't know that I ever, I don't know that I ever said that to him specifically.
Okay. And Arizona is a one-state recording state, is that correct?
Yes.
You have every right to record that conversation without any concern about violating the law, is that correct?
That's absolutely correct.
Okay. And you did in fact record that conversation, is that correct?
I did.
You recorded a conversation of Mr. Wood talking with Summer Shiflett, is that correct?
Correct.
And then subsequently, you also recorded the follow-up with the police interviewing Summer Shiflett, is that correct?
To be candid, I believe it was the same recording. I believe that when I went into the Chandler Police Department on that date, I turned my recorder on, and I believe it was one continuous recording of the entire exposure with the Chandler Police Department, including the initial conversation with Mr. Wood.
And that's what you anticipated my question. So in other words, when you turned your recorder on, it was a complete recording of the entire conversation between Mr. Wood as well as the Chandler Police Department and interviewing Summer Shiflett. Is that correct?
You know, the only word I'm not comfortable with in that sentence is complete. I don't remember when I turned it on. My recollection is that I turned it on when I first walked in. I may have turned it on after having been in the lobby for a few minutes. Logistically, this is how it worked out. We walked into the lobby of the Chandler Police Department. Mr. Wood and several others came out to meet us. Then we went into a room with Mr. Wood, his deputy, and my client. And it was prior to that that I turned on the recording device. I don't remember when I turned it on specifically. I'd have to listen to the very beginning of it again just to remind myself of that. But it was prior to going into the room with Mr. Wood and his deputy and my client.
Okay. And we're going to have an opportunity to listen to that tape in a moment or two. But so your recollection is that the entire recording, other than you, given your representations, were recorded as an entire document. In other words, you had your recording, and at no time did you turn it off. Is that correct?
That's my recollection, yes.
Okay, at no time did you modify or edit it. Is that correct?
That's correct.
And at no time did you make any changes to that recording. Is that correct?
None.
Okay. But the recording was one in a complete document that included not only Mr. Wood's discussion with Summer Shiflett prior to the interview by the police, but also the interview by the police of Summer Shiflett. Is that correct?
That's correct.
Now, it's at some point then you presented that audio tape to Mr. Woods. Is that correct?
I did not present it to Mr. Woods, no.
You provided Mr. Woods a copy of a tape recording.
I did not.
You provided the discussion between Mr. Woods and Summer Shiflett to Mr. Means. I'm sorry, I said to Mr. Woods.
Yes, sorry,
Mr.
right, yes.
I apologize.
Yeah, I don't believe I ever gave a copy of it to Mr. Woods, but
Right.
I did send a copy of it. When Mr. Means requested it, I got permission from my client and sent it to him.
Okay, and I apologize, I misspoke.
That's okay. A lot of parties.
Yeah. So at some point you presented the recording to Mr. Means, is that correct?
Correct.
Prior to presenting it to Mr. Means, did you take any other actions in regards to this recording?
I did. Before I did anything, I contacted the State Bar of Arizona. I sought counsel from them with regard to a couple of things. Number one was what I needed to do to disclose it. And if I could, given the fact that it was recording for a client and, you know, that kind of a thing. And we had a long discussion as well about the legality and the ethics of recording another attorney, and about, you know, somewhat the substance of the call.
Okay.
But not as much about that. I wasn't as concerned about my bar's opinion on that.
Okay. So may I inquire of you, what were your concerns about why you felt you needed to disclose it to Mr. Means?
Why I could or couldn't?
Why you did? Why did you take that action?
Because Arizona has had a long history of ethics and opinions with regard to recording of opposing counsel or other counsel. And don't cite me on this, but I believe it was a 1977 ethics opinion that came out and said, Arizona, we're not going to record each other. And then there were 3 other opinions that were issued with regard to that indicated multiple exceptions to when recordings could be made.
Okay.
And so I just wanted to be clear about it. I thought I was well within my ethics to record a conversation. One of the exceptions is to protect a client's exposure for perjury. And, you know, so I wanted to know exactly what they said when they made statements to the police. So that was my reason for inquiring.
So I guess you led into my question.
Yeah.
You had concerns while you were present in that meeting that your client may be susceptible.
Absolutely.
And as part of that discussion, you were concerned that Mr. Woods was coercing your client, Ms. Shiflett. Is that correct?
Well, I didn't have the concern going into that, but I mean, obviously, it's not why I turned on the recorder. But during the conversation, I was concerned about the conversation that they had.
And at this point, upon participating in that meeting, you strongly felt that Ms. Shiflett had been influenced by Mr. Wood. Is that correct?
I was bothered by it to the point where I called Mr. Means and said, you know, you ought to be aware of a few things.
Okay. And what specifically bothered you?
It bothered me that there was discussion about potential punishment for my client's sister. Mr. Wood was well aware of the emotional relationship between my client and the defendant, Lori, Daybell Vallow, or whatever we're calling her.
Okay.
There was a recording that Mr. Wood heard between my client and her where my client was just vehemently upset and angry. And you could tell the emotional turmoil that she was going through. And I thought it was, it concerned me that he was discussing potential death penalty results for my client. It concerned me that he was discussing the theory of the case with my client prior to her being interviewed. It concerned me that he was saying things about Mr. Means and his competency to handle this case. He said it not only to my client, but if my recollection's correct, he was kind of inferring that I wasn't aware of Mr. Means' level of experience and that, he was in over his head on this case. Wasn't my experience in interacting with Mr. Means. And I was concerned about that. I thought it was at a minimum unprofessional. On the other level, placing yourself in an improper role with a witness, to have those kinds of discussions.
And the improper role you talked about is Mr. Wood, in essence, was turning himself in as a witness in this case, suggesting the theory of the case to a material witness. Is that correct?
Well, and not only that, but offering evidence about some of the witnesses, in terms of his interactions with Mr. Daybell, those kinds of things. I just saw no purpose for that. Other than to have a discussion with a witness. I also thought it was, and I was in the room. I was part of the discussion. I don't think I had much to say during it all, but there were just it was described as kind of an introductory conversation. We had a similar one with my client Zulema Pastenis, but that one had more to do with her use immunity agreement and just kind of finalizing those details and getting that signed and things like that. But this was, just want to take a chance to say hi and things like that, which I get. It's important to know the parties, but the conversation didn't go that way. It wasn't like, hi, I'm the prosecutor, this is my deputy, and we're going to be the ones in the room that you're not seeing, listening to the interviews. That kind of stuff I would have expected. But, I've been practicing, and you've not asked me this, I've been practicing for 27 years. It was curious. I hadn't seen anything like it. I was curious about what the purpose of it all was. It was much longer than it needed to be a simple introductory conversation. And there was, like I said, several things in the conversation that were said that made, buzzers go off in my head.
Okay. I want to lay a little bit of additional foundation in regards to the recording. My understanding is that Mr. Wood had approached you and said, I want to come down to Chandler, Arizona to do a meet and greet with Summer Shiflett and Zulema Pastenis. Is that your recollection?
I don't think that's exactly how the conversation went. To be candid, I think it was always in terms of, we are going to come down there. We're going to be interviewing other witnesses. We'd like to speak to your clients. They were interested in speaking to Summer and Zulema and Melanie and Ian. That was the ones they had spoken to me about. It was not a meet and greet. It was an interview. I took it to be a formal, the police are going to be coming, the FBI, the, other law enforcement officials are going to be sitting in there with regard to the multiple investigations that are ongoing, to which my clients are directly or tangentially involved. And so it wasn't, Rob Wood, the prosecutor, coming down to meet these people. It was the legal team that was prosecuting this case coming down to conduct interviews in a formal investigation.
So when the witnesses are going to be interviewed by the police, you anticipated that as part of this process. Is that correct?
Correct.
And you anticipated that Mr. Wood advised you that he was going to come down and introduce himself to your two clients. Is that correct?
I don't know that he said it in those terms, to be candid with you, Mr. Pryor. I think I knew that he was going to be here. I kind of implied that he was going to be here based on the conversations that he was saying we're going to be coming down there.
Yeah.
I've participated in many interviews with investigations where the prosecutor participates and where he doesn't participate. And I don't know if he was intending to be an active part of that investigation or do anything. I've had it where the prosecutor sits in the room the entire time and is part of the process or is proposing questions to the investigator. I didn't know what the logistics of it were going to look like, but I did have an understanding that he was going to be there.
Did you have an understanding that after Mr. Wood introduced himself, that he was going to question, or excuse me, I misspoke. Did you have an anticipation that Mr. Wood was going to introduce himself to Summer Shiflett and then proceed with 18 minutes of discussing the case with Summer Shiflett without asking only one question?
I didn't have any idea what that meeting was going to be like, other than, as I said, my 27 years of experience. I expected there to be some handshaking at the beginning, and then, we'd go into the formal business that we were there to do.
Okay.
He did not anticipate to me in any way, shape, or form, or maybe not the word anticipate, but he did not forecast in any way to me that type of a conversation was going to take place. No.
Were you the party initiating the contact with your client Summer Shiflett and Zuluma Pastenes, or was it Mr. Wood initiating and trying to set up the interview process?
No, this was initiated by the prosecutorial, or the prosecutor and his investigators. And to be candid, John, I don't remember, Mr. Pryor, sorry, I don't remember who contacted me first, if it was the investigators or Mr. Wood, but I had been contacted by both the investigators and Mr. Wood with regard to the interviews. We had been trying to set it up for a while. I think this was our second or third attempt to get them scheduled. I think second attempt. And no, I did not initiate that. Both of my clients were pretty much done talking about this case, other than when they needed to. So I wasn't reaching out to anybody to say, hey, they want to talk to you. If that's what you're asking. This was in response to a call and a question that they wanted to speak to my clients.
Okay. So I want to go through some of the concerns you have. Now, you're familiar with the ABA rules of professional conduct, are you not?
As a practicing lawyer, I am.
And that's part of every lawyer's training. And on my recollection, it's been some time, and we share a similar length, or at least close to a similar length of time in practicing. But ethics is taught, I believe, in the first year of law school, is it not?
I don't remember when I took my ethics class. It was within the first 3 years for sure.
But ethics is an important part of the process of being trained to be an attorney and being educated as being an attorney. Is that correct?
Correct.
And there are specific rules that attorneys are bound by in terms of ethics. Is that correct?
Correct.
And there are specific rules that a prosecutor is bound by in terms of ethics as well. Is that correct?
That's correct.
And as a former prosecutor, my prosecutorial experience is very limited, but and I didn't get into your experience, but as a former prosecutor, you're well aware of your ethical obligations, right?
I was a prosecutor for 3 years for Maricopa County, which is the largest prosecuting agency in the state of Arizona. And yes, I'm aware of those duties.
Okay, and part of that ethics responsibility is the administration of justice. Is that right?
One of them.
And that's one of the responsibilities to make sure that justice is performed evenly and fairly, and that both parties are afforded a fair opportunity to present their cases. Is that right?
Yeah, I mean, the way I always looked at it as a prosecutor was it's adversarial, but it's not win at any cost. You have to do justice first. And, there's certain standards and not certain, there are standards that are higher than for a normal adversarial process for a prosecutor.
Well, what that means is the prosecutor has to conduct himself in a manner that doesn't interfere with the administration of a fair and impartial trial in front of a jury. Is that a fair assessment?
I agree.
And you would probably understand that every jurisdiction, including Idaho, has rules of professional conduct that are all similar based on the ABA rules. You would agree with that, right?
Yeah, I'm not as familiar with Idaho, obviously. I've never practiced there or done anything, but I'd be shocked if they didn't have rules that mirror the ABA standards and Arizona standards for that matter.
Okay. So I want to go into a few specifics in regards to the recording that you provided to Mr. Means. You talked about initially about Mr. Wood discussing with Summer Shiflett the prospect of going forward on a conspiracy to commit murder charge. Can you elaborate on that a little bit for me?
Well, he had a conversation with her, and I don't recall the exact specifics about it, other than it was brought up that, I mean, it was an awkward moment. You know, my client was expressing her, at some point in the conversation, was expressing her ambivalence, or not ambivalence, or kind of being juxtapositioned in this case. She was here testifying on behalf for the state in an interview, going to be offering testimony that was potentially going to be used to harm her sister. And that bothered her on some level, because she was, you know, she loves her sister, and she expressed that to Mr. Woods. And then to have him talk about, you know, bring up in that same context, or in that same conversation, the fact that he's going to be going forward potentially with charges that could result in the death penalty for her sister, was that concerned me. I didn't think it was necessary. I don't know what purpose it served, other than to you know, put a thumb on my client, and to, you know, attempt to you know, elicit testimony from her that would be favorable to what they were trying to do. And there was a difference here, because it had been made clear to me, and it was made clear to my client in that meeting, that what they were most interested in was information about Mr. Daybell, and that they had a solid case against my client. And I had communicated that to them. You know, there were preamble conversations to this conversation that we had the day of the interview. Mr. Wood and I and the investigators had spoken about this case. They told me their theory of the case. They told me what they were looking for and what they were angling towards. And they definitely, I was aware of what they were doing and where they were going with this. And so to have him then say those same things to my client that day, I felt unnecessary. And I mean, I'm a nice filter. Tell me that you're considering the death penalty against my client, and I can express that to her in a setting that's appropriate.
Well, it's not the death penalty against your client, it's against her sister, her own sister.
And I'm sorry, I got to pause for 1 second. There is someone knocking on my door, and no one is here to answer it. So if I can pause for 1 second and put you guys on mute.
Well, Judge, if we could do this, I think at this point, it may be an opportune time for us to listen to the 18-minute conversation between Mr. Wood and Summer Shiflett. If I could ask the court to allow that tape recording to be published once Mr. Smith comes back.
Well, my concern there is we're in the middle of this line of questioning, and I have not provided an opportunity for cross-examination yet. So I'd like to take that up first before we get the request. And it looks like Mr. Smith's already back.
Okay. Sorry, I just need to answer my door. I apologize.
All
Working
right.
from home has its own exposure.
And Judge, at this time, it's my preference that the court allow us to publish the tape, allow Mr. Smith to listen to and review the tape before I proceed with any additional questioning. In no way do I want to impede the prosecutor's ability to question Mr. Smith, but I think this would be a good opportunity for that tape to be played to allow all the parties to listen to exactly what I'm referring to.
Okay, well, the conversation, the recording of that's been admitted in the hearing, so you can go ahead and publish that at this time, Mr. Pryor, if you so choose.
And Mr. Means, you had spoken to me earlier this morning and indicating that you had that available. I would defer to you if you could record, if you could publish that for us, please, sir.
Will do.
They're the ones kind of running down the kids' case because they were last seen in Rexburg. Or were last living in Rexburg.
Right.
Tylee was last seen in Yellowstone, but and so we were the ones that like knew everything about the case. And so they assigned us on that. I'm just going to tell you right now, we are going to be filing conspiracy to commit murder charges against both Chad and Lori.
Good.
And we're not shy about that. I've told their attorneys. His attorney keeps pretending like I've never said that. Whatever. What? But we have to. Yeah. We have to. But I kind of want to give you like a little bit of background of where we are, and kind of like our kind of theory of how this ended up where it was. We know that this is not the same Lori everyone else knew. What's so strange to me is everyone we talked to who knew Lori before this, like, well, she was primary president. She made quilts for these kids. She made everything fun. Mm-hmm. Everyone loved her. She loved everyone.
Great mom.
Great mom. That's what everyone says. And you know, so the one thing I'm going to kind of ask you to consider is maybe something happened. I don't know what. I don't know if it's psychological. I don't know. I don't know if we'll ever know. But something happened, and I think Colby, the way he said it to me, I think is kind of it's like the person who's in that jail cell is not my mom, it's someone else.
Yeah.
The flip side of that is that I shouldn't say the flip side, but I want to be clear. I'm not going to pull any punches on any defendant in this case, right? Like, I've got my job to do. And,
absolutely.
But we also want the truth and the whole truth and the context of it. And Chad Daybell is. Did you ever meet Chad?
So I met him once at a Preparing People. I went to one Preparing People thing, and my mom and husband and I went to support Lori, and she wanted to support Mel. So we went and met Chad after he talked for like 90 seconds, maybe, if that. And then he called me when Lori got transferred to the Idaho jail. He texted me and said, Lori wanted to talk to me. And I was like, yeah. And then the second I hung up with her, he called me to ask me about bail for Lori. So I've talked to him maybe 3 times briefly on the phone, never a long extended conversation. But the first thing he said to me when he called me was that he said, Lori hasn't told me very much about the kids, so there's not really much I can tell you about it.
Right, of course you said that. Well, welcome to Chad Daybell. So what I want to kind of tell you,
I have my own opinions formed of him.
I bet you do.
Yeah.
He's highly manipulative.
Yeah, I see that.
I'm not going to say he's highly intelligent, but you don't have to be highly intelligent to be highly manipulative.
Absolutely.
He is extremely manipulative, and I want to. Your sister manipulated him in some ways too, but the context for everything that happened came from Chad.
Absolutely.
And unfortunately, we have enough evidence to prosecute him, and we are. The case against your sister is stronger, but I kind of want to give you that background. That's kind of the context we see this as. Like, this guy came in here, and again, I'm not making excuses for anyone, but kind of blew up this situation. And he did not care who died, who got hurt. He did not care at all. And the other thing I'm going to tell you is your sister truly believes that everything she's done has been done in righteousness.
I know.
And I know I'm kind of using LDS speak.
Yeah, it's 100%. That's my interpretation also.
Yeah.
I think she 100%.
She believes it. Every once in a while, you'll see kind of a little crack in like a jail phone call. Or she'll.
Well, you've heard our conversations, so you know that I get that she's not fully aware of what she's really done.
Right.
Yeah. I don't think she is.
Yeah, I mean, I'm going to say this, but I think she knows what she's done.
She knew enough to lie to us about it.
Yeah, but the context under which it was done was this religious, just these ideas that are out there. I can say this because I am LDS, like no basis in the LDS faith, right? Just, you said it in her phone call to her. So anyway, that's kind of where we're at. And but again, we're just really grateful for you coming in. And it's going to be hard to talk about these things.
Oh, yeah.
We know that. And they're going to be nice. Because obviously you're not even a person of interest.
Yeah,
in
we've
this.
had
You're
that
not
conversation.
Yeah.
Yeah. And, but part of what we need to do is understand when you have a case like this, it's not like just like a meth case, like, oh, you had meth, no one cares who you are. And
Yeah, there's no drugs, no alcohol.
Yeah.
It's just
But
bizarre.
this case is we need to understand the context of who these people are.
Yeah.
And so that's a lot of what they're going to be asking you about.
Okay.
And
I'll do my best.
like I said, I know it won't be easy. I know it's going to be a hard interview for you, but
I was wondering if you would be willing to tell me, if you're able to tell me, if there's any progress in what you know about Tylee and her death. Is there any progress in her autopsy where you understand better?
all I can tell, well,
I mean, do you have a cause yet, or is it close to one?
she is at the FBI's state-of-the-art crime lab. Unfortunately, there's a lot of deceased bodies there that they're going through.
I'm sure.
And so we're not, we don't know really anymore yet. And we may never know due to the the destruction of that body. And yeah, we hope we'll find out. We may not, but obviously we know it's her. There was soft tissue that was still preserved enough to do DNA tests.
Yeah, I'm thankful you guys found them. Like,
Yeah.
we wouldn't have ever known.
Yeah.
And I would have never dreamed that she would have ever heard them. So.
You know what? And everyone says that.
Yeah.
That's what everybody says. I never would have. So it's a tragic thing.
It really is. Yeah.
And but I just want you to know how grateful we are. I know you don't have to talk to us, and so we're just grateful that you're willing to and helping us that way. And I'm sure kind of difficult knowing like they're asking me for information that's going to help them in a case against your sister, but I guess the thing I want you to know is our whole goal is just justice for these kids, you know. And we, I mean, our hope as it comes to it. Your sister's actually made some overtures. She might be willing to talk to us.
I hope she does. I pray for that all the time.
We hope she does.
Yeah.
She actually was talking with Chad about talking to us before we found the bodies, just a few days before, and he talked her out of it, which is too bad. It would have been better for her to tell us.
Yeah, sure would have been.
I mean, we were actually just finishing up our warrant on the day that she said that. We were just getting ready to go out there, but it would have been, that would have been even better, and he talked her out of it.
Yeah.
And then the night before, she says to him again, like, hey, what do you think about, and he uses this kind of, I call it spiritual abuse, spiritual manipulation.
Yeah.
We've all seen that guy in the LDS religion whose wife has to obey him because he has the priesthood type thing. And that's not what he says, but it's the same type of thing.
Mm-hmm.
Well, I'm the visionary guy. So, anyway, again, I just wanted to meet with you real quick, introduce myself and Mackenzie.
I've obviously seen you.
Yes, yeah. Yeah.
But I don't take any joy in doing anything that's going to harm her. I don't take joy in her spending her life in prison. There's nothing.
Sure.
It hurts to think about her being in there.
There's nothing good about a case like this.
There's
right?
nothing good about it.
Even if you win a case, like Garrett's been in court, like there's cases, even as a prosecutor, like you take to trial and you win, and you're like, even at the end, you're like, well, nothing good is. It's all bad.
Yeah.
It's all bad.
The one thing, I said this to someone the other day who knows your sister, is our goal is sometimes you get a murder and all you have is that murder and you just have to run out and charge it and then kind of put it together. We were able to put them in jail with a high bail and these lower charges and put together a case. And our goal is to have such a strong case that when she has competent counsel, I don't know if you know this, her attorney's never handled a felony before. He has never done any meaningful criminal work at all. And he doesn't know what he's doing. He's a nice guy.
Yeah.
Other one he's lying about me, but he doesn't know what he's doing. And once we file further charges, she will be appointed counsel who will know what they're doing. And our goal is to put together such a case that they're smart enough to say, it's going to be better to talk, and I think we are, and make it easier for everyone, make it easier, especially, for Colby. Like, if there's someone who's lost everything, it's him. So anyway, I mainly just wanted to thank you for coming and being with us. And
it's weird to be on the prosecution and defense's side at the same time because I love everybody.
Well, it's a system. I did defense work for I did it for 5 years, and I actually really enjoyed it. I thought it was a lot of fun.
I like defending.
And and I gave me that perspective, right? Like, just because someone's committed a crime doesn't mean they're a horrible person.
So I'm so torn with all of it's such a conflicting feeling to know that this person's been good her whole life and then has made this error in judgment and got sucked into this vortex of this man. And I feel for her. I just have so much compassion towards her because I know that's not what she would have ever done on her own.
Right.
And so she has to pay the price for this forever. And I hate that for her. So I'm very conflicted. But I was going to ask you on the concealment, or not the concealment, but on the conspiracy to commit murder, what's the weight of that in terms of jail time? Is that a death penalty thing? Or
it is a death penalty case in Idaho.
Are you planning to ask for that for them, or do you not?
We sure hope we don't. Okay. A lot of that will depend on her.
Okay.
And it's that's not a decision that's a decision we don't make actually until usually after the case is filed.
Okay.
In Idaho, we have a couple months, because a lot of times you file it, it's out there on the table, and then oftentimes that's a big motivator for people to get together and talk and try and resolve it. And that's what we hope happens. I have no desire to do that. Plus, once you do that, it's endless appeals.
Yeah.
I don't think the other family wants it at all because the
prolonged.
case just never resolves, really, in a way. Just kind of, they appeal this and they appeal that, and it can go on forever. So we're sure hoping not to go down there. No, I'm not saying I won't. If we go to trial, I might, but we haven't made up our minds on that.
Okay.
We don't want to. I can tell you that from the bottom of my heart.
Knowing her, if she comes out of this state and realizes the weight of it, she may prefer that. Honestly, I think about that all the time with her, just because of what she's been through. I'm just kidding.
Well, I know that you know a lot more about Lori than I do, but we have learned a lot about Lori, and there's I mean, there's been some things happen in her life, I think, that have played into this.
Oh, definitely.
And but yeah, like I said, I talk of that in one way a little bit sure, but I want you to know that I have no desire to
yeah, I think you see it for what it is.
Yeah, it's not
I don't know how you couldn't with interviewing your
well, it's I mean, I'll tell you, when I was there in Hawaii, when that the order to produce the children was served, and I was there when they served the search warrants where the news showed up, which I was super annoyed by that. I never want it. It's just blows everything up, right? At that moment when we saw them, your sister can put on a brave face.
Oh yeah.
We were like, oh, does this guy know what he's gotten into? And because she was just very, very stoic, very like, I'm not going to say a word. And he looked like he was about to pee his pants because he's actually a wimpy person.
Yeah.
Is he wimpy?
Yeah. He's great if he has someone else to do something for him, but he himself is a person. And at the time, they're like, this is all her. Like, how is she hoodwink this guy? But then once we like dug into, that was the beginning as we're like starting to get facts. As we got more facts, like, oh, again, I'm not going to pull punches if I have to go to trial, but these ideas came from him.
Oh yeah.
And she had some different views on theology than like standard LDS by that point, but he really knew how to manipulate that and turn it into something even more.
His influence was there before she met him.
Yes. Yeah, she was reading his books for.
Wasn't just his books. So it was like the Julie Rowe podcasts.
Oh, yes.
He gave Julie Rowe a lot of her ideas. And so when she would listen to Julie Rowe, she was getting Chad ideas too at the same time.
Yeah,
so.
oh yeah. Yeah, Julie Rowe, she's interesting.
I've heard some of her podcasts. When she started talking about herself in third person all the time, I'm like,
Yeah, I listen to her podcast as well, and interesting stuff. So.
Garrett doesn't like it when people talk about themselves in the third person.
Yeah, neither does Rob. Yeah. Well, hey, we'll let you get going and start on this.
I was gonna see if you guys wanted some wristbands to take back with you. These are wristbands I had made up for Tylee and JJ. And
that's all right.
Take them as you want.
Give them to everybody.
I'll tell you what.
If you want them, we did a balloon release.
They've got a couple of wristbands for. Let's see. There's Ron, Ray.
You can just take the whole bag with you. It's fine. Just take
do you have more than this?
Oh, I have plenty.
Okay.
You can't order less than 100, so you know.
Yeah, I made up hundreds for. I started off just doing them for Tylee and JJ's friends and teachers. We wear ours all the time, so just keep them close.
Thank you.
Yeah. You guys.
Sorry.
That's all right. It's okay.
You've been in it. You know.
Emotional thing.
You know, it's interesting how you can, in Rexford, those kids weren't there very long, but there are kids.
Yeah.
And
anytime there's kids involved, it's not okay.
So, thank you.
Yes.
There's not a one among us that doesn't want to protect the kids.
Right.
Yeah.
For sure.
All right, I'll text Nate and remember. If you need, I don't know how long if we want to, we probably sit down and talk to you for days and days, and we obviously don't have that, but any breaks you need anything?
Yeah, I'll run it. You bet. Yeah. I told him she's got questions, needs to ask me or needs to use the bathroom, or we'll shut it down and do all that. So.
And Judge, I think that's the end of the tape.
Okay, thank you. And just so the record's clear, that was Exhibit 2 that was published. So, Mr. Pryor, you can proceed with or continue with your direct examination.
And Mr. Smith, are you still there?
Yes.
So, Mr. Smith, I've had an opportunity to listen to the tape several times and again listened to it today. Is it your position that Mr. Wood was trying to influence Ms. Shiflett to testify in a particular manner?
I don't know what he was trying to do. I can't think of any other reason why he'd be doing that than for that purpose.
Well, that's what the question is can you come up with any conceivable idea as to why Mr. Wood would do that other than the fact that he was trying to coerce, intimidate, or manipulate a material witness in a criminal case?
Yeah, I other than for the purposes he stated, just to get to know them. But like I said, that was much, much more than that. It wasn't a simple meet and greet. That conversation had a lot more elements to it than that.
Well, and I want to go over a few of those elements, and I don't want to drag this on, but some of the elements that I want to go into is that Mr. Wood made reference to LDS speak and righteousness, invoking his religious beliefs to Ms. Shiflett. You would agree with me that knowing Ms. Shiflett, that would influence her in a certain way, right?
Yes.
And you would agree with me that Mr. Wood, being a former bishop of his church, invoking LDS speak and his religious beliefs, would have an impact on Ms. Shiflett. You'd agree with that then, correct?
Again, religion's very important to Summer, and her membership in the church is very significant to her. And that kind of a correlation was unnecessary in my mind to make that. Everybody knew that Rob was LDS and that he was Mormon, and I don't know if Summer knew that he was a bishop or not, and he didn't say that in this conversation. But again, that whole, hey, we're the same, we're on the same team here. We're, not only it just felt awkward and unprofessional to be talking that way.
Well, you're being kind in this case because it was a little more than awkward. It was completely unprofessional. Wouldn't you agree with that?
Well, it was awkward for sure, and as I said, it was unprofessional.
All right, and the unprofessional nature is that he invoked his religious beliefs, right?
Well, you heard the tape. What he said is there's just that comment about righteousness, and I think when he was talking about the LDS speak, he wasn't necessarily trying to equate so much with Summer as he was with what Chad was doing, but just that whole notion and nature of that coming up was something I probably would have steered clear of.
Right. Well, you would agree with me that anyone on a supposed meet and greet wouldn't be invoking their religious beliefs in a casual conversation, right?
Yeah, it didn't have anything to do with the purpose for which that conversation was going on.
So we can assume then that the purpose of invoking the words LDS speak and then subsequent to that, a short time later, where he says, "Oh, I am LDS," the purpose of that was to gain favor with Summer Shiflett, right?
Yeah, it's the kind of thing that you're having a meet and greet and you're introducing yourself. You might want to tell them that you've got kids or something like that, which that's something that would be normal and even to everybody. But the religious side of it, again, you wouldn't do that in front of a jury, and doing it in front of a witness that hasn't yet testified, I found concerning.
Well, that's a good point that you bring up, and that's going to be addressed later on with some of the other witnesses. But if this sort of conduct, where you invoke your religious beliefs, and we're a prosecutor and you're a defense attorney, if you invoke your religious beliefs in front of a jury, that's an absolute mistrial and a disqualification of the prosecutor for prosecutorial misconduct, right?
Again, I would assume that it would cause problems. I gotta be honest, I've not looked at what consequences that would have, but I mean, it's absolutely taboo. I wouldn't do it, and I've not ever seen anybody do it that I've been involved with. It's just, it's more like vouching or saying, "Hey, I know this guy didn't do it." When you start talking about things like that or trying to equate with the jury every attorney that's in front of a jury is trying to build a relationship with them, but you have to be subtle about that. You can't just go, "Hey, any of you LDS? I'm LDS." It would be completely improper.
Well, not only improper, it's something that falls within the guides of professional conduct. That's a basis for opposing counsel to ask for a mistrial if anybody enters their religious beliefs in front of a jury, right?
Absolutely.
So my question is this: to kind of do a back way into this, Mr. Wood, on the supposed idea that he was going to do a meet and greet, proceeds to engage in Miss Shiflett. And by my recollection, he only asked a couple of questions, but there was a lot of discussion. And in that discussion, he invoked his religious views. So in other words, he's telling a witness who is going to be testifying in the trial, "By the way, I'm LDS. By the way, I'm Mormon. Show me some favor." And that way, when you get in front of the jury and you offer that testimony, the intimidation and the influence has already occurred before you get in front of the jury. So in many ways, isn't that worse?
Your Honor, I'm going to object. Mr. Pryor is testifying. It's not a question. He's leading the witness to an answer.
I'll sustain the objection.
What's worse, doing this in front of a jury or coercing and intimidating a witness prior to the time they go in front of a jury?
Your Honor, I'm going to also object to the question. This doesn't have anything to do with the jury. It's just a witness in a case. So it's not relevant.
I'll sustain that objection based on relevance, and I think it did misstate the statements contained in the recording, which we just listened to. So that objection's also sustained.
All right, I'll move on, Judge. Thank you. What about calling a defendant in a case a wimpy person, Mr. Smith? Is that problematic?
I know there's a lot of bluster that goes on in prosecuting people that do violent things. I never prosecuted murder cases. I was involved with prosecuting child molesters. And there's a fair amount of banter that goes on amongst the professionals in there about these kinds of people. And so I've been to lunches where they referred to child molesters by lots of names that were demeaning and not nice and unprofessional. But it's in a professional setting. I'm at lunch with other prosecutors or cops, and we're talking about what we think about child molesters. But in the context of talking to, the sister-in-law of the individual that you're talking about, I didn't see a purpose for that. Other than to, kind of seed the ground for her testimony to be of a similar vein. And, this is what we're looking for, kind of thing. And that was concerning to me.
And the concern is that Summer Shiflett is a witness potentially in this case, right?
Right. I mean, again, and I haven't been a prosecutor in a long time, but to talk to someone prior to them giving 6 hours of testimony and interview time on the facts of a case in this manner, I found it to be improper. I don't know what purpose it served, other than to kind of muddy the water and make himself a witness.
Well, and make himself a witness because he then went on to discuss the fact that when he was in Hawaii, I don't know why he was in Hawaii other than apparently he was in Hawaii, but then he observes what he says is appears that the defendant, Mr. Daybell, appeared that he was about to pee his pants. What's the purpose of saying that to Summer Shiflett?
Your Honor, I'll object. That just calls for speculation.
I agree. It is speculative, but I don't know. That's my whole point. I don't know that. And Mr. Pryor, let me say this too, just in response to that last question.
Mr. Smith.
I'm sorry?
Mr. Smith, please.
Yes.
We're on a Zoom proceeding. We're making a record here. I have a court reporter.
Okay.
Wait until the questions are finished, and when there's an objection, please wait for the ruling on the objection before you continue with your response, please. Thank you.
Sorry, Judge, I'm not good at being in this seat. I apologize.
Understood.
Where are we at?
I heard an objection from somebody. I'm not sure who objected, but I'm waiting for the court's determination.
I sustain an objection by Mr.
All right, I'll continue on. Mr. Smith, you had some discussion about a prior question and that you had a comment, and if you want to relay that comment, by all means.
This conversation that I had with my client and Mr. Wood, again, and just earlier I had testified that I didn't remember when I started the recording. From listening to the recording, I clearly started it after I got into the room. And to be completely candid with this court, my intent was to record the conversations of the interview. When I walked into the room with Mr. Wood, it had a less of an introductory feeling to it because he brought his deputy in with him. And again, part of the training that I received as a prosecutor and that I still employ as a defense attorney is that there needs to be somebody else in the conversation that can be a witness in case there's a dispute to that conversation. So if I'm interviewing a witness and I ask that witness about X, Y, and Z, and then they come into court and testify A, B, and C, I have to have some method of impeaching them, either through another witness or recording of the call or something like that. So a flag went off in my mind when he brought his deputy in to meet my client and myself, and to kind of do this introduction stuff. And that's when I got my recorder out and turned it on. That put a flag off in my mind that this wasn't going to be, hey, I'm John, or I'm Rob. This is my deputy, good luck today. Thanks for doing this. And we'll talk to you when it's all done. It was more than that. And that's when I turned it on. And I wanted to supplement my previous testimony. Like I said, I hadn't heard the tape recording in a while, and I didn't remember when I'd turned it on.
And when you make mention of the fact that a flag went off, you're referring to the fact that you felt that there may be some inappropriate discussion going to take place. Is that fair?
No, I didn't think it was going to be inappropriate. I thought it was going to be adversarial. Okay. And the fact that he was backing himself up with a witness told me, at least it made my, the flag, the spider senses, whatever you want to call it, the defense instinct, that I needed to be recording this conversation because he's got a witness in here. I need to have my recorder running. I had no idea that the conversation was going to go the direction that it went.
And having participated in the conversation, the 18-minute discussion, because this wasn't Mr. Wood questioning Summer Shiflett, was it?
No.
This discussion was Mr. Wood presenting his case to a witness. Would you agree with that?
Yes.
And Mr. Wood attempting to influence Summer Shiflett to testify a certain way. Would you agree with that?
Again, I don't know what his intents were, but I can't see any other reason to tell her the things that he did other than to steer her in that direction.
And when you say steer, you mean influence, do you not?
Correct. It's another word for that. Yes.
Okay. Judge, I think at this time, I'm done questioning with Mr. Smith. Thank you, Mr. Smith, and I'll defer to the court at this time.
All right, thank you. I'll allow cross-examination at this time. Mr. Evans.
Your Honor, thank you. Mr. Smith, thank you for being here today. Just a few questions. Where was the recorder at when this was being recorded?
It was my phone. It was this phone. And it was either in my hand or it was sitting on the table. I don't remember. I think we were standing for this conversation. I think we never sat down. We were standing in a small ante room off of the entry lobby of the Chandler Police Department. I think I'd set my stuff down on a table and my phone was on top of that.
And just so I understand this, Mr. Wood or the law enforcement, they contacted you and you contacted your client and you agreed to this conversation taking place, this meeting taking place?
Yes.
Mr. Smith, I mean, we're all lawyers. If something gets out of hand, and I know you've done this and we've all done this, but if I'm getting on your client's case, you can say, Evans, time out. Or I'm going to direct my client not to answer that question, or this interview is over, right?
Sure.
At no time during this meeting did you ever object to any question. Is that correct?
Yeah, you know, I was doing what my client wanted to do, which was to participate in this interview. And you got to understand, I wasn't running it. She was running it. I was there as legal counsel and she wanted to do this interview. She wanted to give testimony. She'd been asked to give testimony in that sense. And so she was going to do that. I didn't want to shut this down, but that doesn't take away the concerns that I had at the time. There also wasn't a forum to go to. You know, if I've got a problem with the question you're asking, I could object to it in a setting, not in this setting. It's not my position here, but there's a judge to go to, or you know, hey, let's table this right now and straighten this out in a deposition or something like that. But it wasn't that type of setting. This was unique. Like I said, I've done this type of setting many, many times, but to have this kind of conversation was a little bit, oh, we're doing this. Okay. And I didn't know where it was going to go. I knew I was recording it and I could deal with it later.
But you could have objected or told your client not to answer or ended the conversation, right?
Well, as was said, there wasn't a whole lot of questioning going on. In fact, I don't know if there was any questioning other than, you know, a couple of mild questions. It was mostly just conversation from Mr. Wood.
I want to talk about the tone. I mean, you hear you guys are joking a little bit throughout when it was discussed at the very beginning that murder charges might be coming on this. You said good, right? Do you remember that?
I don't remember that, but I don't dispute it.
Is your client a vulnerable adult by chance?
No.
Have any medical issues or anything that makes her incompetent to testify?
Not that I'm aware of.
And then finally, I want to talk about, you made an issue that Mr. Wood started talking about the death penalty or murder charges. I note from the audio, and I don't know, do you have the transcript in front of you, Mr. Smith?
No.
On page 11, starting in paragraph 5, it's pretty clear that your client was the one that initiated that conversation with Mr. Wood of, talk to me about is death penalty on the table? What's going on?
I'm going to object at this point.
Go ahead, John.
Hold on.
Go ahead. I'll defer to Mr. Means, but I object to Mr. Evans questioning in this manner as suggesting that it's obvious that that's Ms. Shiflett that initiated it. I object to the form of the question.
Same, Your Honor.
The objection's overruled. You can continue. Were we referring to the transcript? I know that's been admitted.
I don't have it, but at least I don't think I have it.
Yeah. And let me just, so I actually misspoke. It's page 16, starting paragraph 2 through 9. But your client is the one that's asking Mr. Wood, what's the weight of the terms in jail? Is this a death penalty thing? Do you remember that, Mr. Smith?
I do. Yeah, she definitely initiated that conversation.
Okay.
Mr. Evans, with the transcript being admitted, if you are going to refer to it, I think, and ask the witness to confirm that, it'd be appropriate if you can publish it based on, I don't know if you have, we should be able to enter it in, and so you can use your share screen to locate that part of it if it's on your computer, and then it comes up on the share screen on the Zoom if you want to do that. And if you're done with the question, that's fine, but for future reference, that's how we need to handle that.
Right. Thank you, Your Honor. And Your Honor, I'm done with that question. Mr. Smith, just a few others. I heard in the interview, Mr. Wood, that told you and your client, hey, you don't have to talk to us, but you have agreed to that. Do you agree with that recollection?
Yes.
And it's important. My last question, you said that you didn't believe anything was inappropriate here, but you had a concern that it might turn adversarial. Can you tell us what you meant by being adversarial and not inappropriate?
Yeah, let me be really clear about that. When there was obviously conversation that had transpired prior to the beginning of the recording, we were several minutes into it by the time I turned it on, and the beginning of it did involve Mr. Wood introducing us to him and his deputy and thanking Summer for coming in, kind of like he ended the interview with, or the meeting with. And I went into it, to the day knowing that I was going to record the interview and was prepared to do that. I told my client I was going to do that, those kinds of things. But did not turn on the recording when I initially walked into this interview ante room with Mr. Wood and his deputy and my client. When I got in there and his deputy was in there, I thought, well, is he bring her in just to introduce, or was he bring her in to have a witness into there for the conversation? And initially the conversation was introductory, and this is a deputy, and we didn't know who she was. I'd never met her before. But then it went from that point to these other conversations, and that's when I reached down and turned on my recorder. Again, when I say adversarial, what made me think adversarial was the fact that he had a witness for the conversation. What made me turn on the recording was the topics and the kind of the tone of the discussion at that point in time.
And Mr. Smith, last question. When you turned on the recording, you didn't say, hey, folks, just so you know, I just turned on the recording. I mean, we don't hear anything like that in any of the tape, right?
No, I did not, nor do I believe I need to.
No further questions, Your Honor.
All right, thank you. Mr. Pryor, do you have any redirect?
Judge, I think, do you want to give Mr. Means an opportunity to cross?
I would. Mr. Means, do you have any cross-examination?
Not cross, Your Honor, no.
Okay, and we'll get to your direct in a moment. Mr. Pryor, any redirect before we move on to Mr. Means?
Mr. Smith, the comment from the prosecutor about adversarial, that was initially what the concern was before you turned on the recording, correct?
That was my instinct, was that he's got a witness to the conversation. Is this going to turn adversarial?
Okay. And then after you returned on the recording, it was because you found the topics and the discussion to be highly inappropriate. Is that fair?
Yes, I wanted a record of it because we were discussing facts of the case, and it was, getting opinions from my client and sharing opinions from the state. It was that kind of conversation. They were discussing the death penalty. We came where it turned on, it was already discussing that topic. That's when I turned it on.
Okay. And then it proceeded to go into disparaging remarks about the defense counsel for Lori Vallow, right?
Correct.
Disparaging remarks about Chad Daybell, correct?
Your Honor, I'll object to the disparaging remarks. There were remarks made that Mr. Pryor is testifying.
I'll sustain the objection in that the recording obviously speaks for itself. And the court can go through what was said on it.
And what I'll ask Mr. Smith is, do you personally consider the remarks made about Mr. Means disparaging remarks?
I do.
Do you consider the remarks made about Chad Daybell disparaging remarks?
They are, absolutely.
Do you have any other explanation other than Mr. Wood trying to influence a material witness in a case for why he engaged in 18 minutes of discussion with Summer Shiflett.
Your Honor, I'll object speculation.
I'll overrule that. The witness can answer if you know.
As I said, I understood the purpose of the conversation to be introductory and kind of just a preamble to the interview. I see no purpose for the type of discussion that we had other than the reasons you suggested.
All right. Judge, I'll defer at this point on this witness. Judge, I would like to have this witness made available in the future in the event I need some rebuttal testimony. Thank you.
Okay, he won't be released yet. We're in the interest of efficiency. Then I talked about the procedure we'd use, but Mr. Means, we've got this witness here. Did you intend to call Mr. Smith as a witness in support of your motion as well?
I did, Your Honor, and just a few questions, not a lot.
Okay, then Mr. Means, if you'd like to commence with any direct examination, you can do so.
Thank you, Your Honor. Mr. Smith, I'll try to avoid repetitive questions here for efficiency of the court. You've listened to this recording. In this recording, Mr. Wood makes reference to speaking to, or sounds like speaking to, multiple people regarding this case. He uses terms of we, talks specifically about having a conversation with Colby. Are you aware if Mr. Wood has spoken with any other person directly in this case?
I'll tell you what I know, and that's just like I said earlier, that he had told me they were coming down here to interview witnesses. I don't remember that he gave me a list of who he was going to interview, but I mean, I could probably name half the list of the people that he spoke to. He did tell us in his conversations in the interviews, not him, the investigators told us some of the people that they had spoken with. But yeah, I understood he was down here talking to other witnesses about the case, and he may have been down to Arizona one other time. As I indicated earlier, this was, I think, the second setting that they tried to interview my clients in.
Okay. Did you have an opportunity to review a pleading filed in this case entitled "The Affidavit of Rob Wood in Support of Objection to Defendant's Motion to Disqualify Prosecuting Attorney and Motion to Extend Time on Motion to Dismiss"?
I did.
Okay. And this document, Your Honor, is obviously in the file. I'm going to read you paragraph 6 from this affidavit, and I'd like your thoughts on this. It says, the meeting I attended with Mr. Smith, Mrs. Shiflett, and Ms. Pastenas came about as a result of Ms. Pastenas reaching out to my office and law enforcement through her attorney, Mr. Smith. Would you agree with that description?
Now, I don't know if Zulema ever reached out to his office prior to my representation, but I don't believe that I ever reached out on behalf of Zulema to initiate this. My recollection is that they contacted me and said, we'd like to talk to your witnesses or your clients as witnesses.
So would it be your opinion that that is not an accurate statement?
That's my recollection. And as I said, I don't know if Ms. Pastenas contacted them prior to my representation, but she never told me about that.
Okay. Well, it says in the paragraph 6, and I'm sorry, the last portion of the sentence, Ms. Pastenas reaching out to my office, in reference to Mr. Wood prosecutor office, and law enforcement through her attorney, Mr. Smith.
Yeah.
So specifically stating it was you that reached out to arrange this meeting.
And here's the unique thing in answer to that question, Mr. Means, here's the unique thing about Ms. Pastenas. Her approach in my representation of her has been to keep her head down and stay out of the limelight and the attention. She's not done any interviews. She's not done any media appearances. She's not agreed to talk to anybody. And the only reason why she agreed to talk to the state is because they wanted to talk to her and they offered her use immunity. And so that's what got us to that point. It was not because she was anxious to talk to anybody, because she was not.
Okay. Okay. I think Mr. Pryor and Mr. Evans covered a lot of the questions I've covered, but I do have just a few more for you. In listening to this recording and the totality of the statement said, you've already testified that it appeared the motive to be influential of the witness. Would you agree it was attempt to coach as well?
The whole conversation, what the problem I have with the whole conversation is that, and I'm not saying that Mr. Wood was in there twisting arms or putting hard pressure on them. You know, I've been involved in situations like that where a prosecutor, threatens charges and things like that. That's the real weight of a prosecutor coming to bear on bringing influence on somebody. It wasn't that type of thing. It was the more subtle I'm a nice guy, and I'm sure he is. You know, you want to help me, help the state, help the case. You know, and it wasn't necessary. She was already there, willing to participate. She didn't need any inducement or enticing in order to testify. I found it, and that's what my first concern about it was. I was like, why are we doing this? She's already come in, consented to all this. We didn't need to soften the beach with these kinds of comments. And so it clearly was to influence her. It clearly was to have her, you know, kind of seated for this upcoming interview that she was going to have. And just, you know, the next room we were going to go into was going to be this interview. And I saw no purpose for it. And I found it to be unprofessional and concerning.
Would you agree, especially taking in context the conversation regarding death penalty and the relationship in which you testified earlier between Mrs. Shiflett and Lori, that this conversation put Mrs. Shiflett in somewhat of a compromised position as a witness?
Look, as I said earlier, I've been doing this for 27, 28 years. I've been involved with legal practice for 30 years. I have never in my life heard a conversation like the phone call I heard between Lori and Summer. It was gut-wrenching. It is raw. It is horrible to listen to. And this is the emotional state of a witness, my client, who has lost one sister to death, another brother to death, and now another sister to jail and potentially death. And I found the whole conversation unnecessary and concerning. It was almost torturous to even be discussing about, well, we may take another member of your family. You know, and I know Rob's not going to kill her. I mean, it's going to be a death penalty. It's going to be a process, and it's going to be, you know, that whole thing. And you know, but just the purpose of the conversation, I didn't see it. I don't know what it was going to do. And it was concerning to me because I know I've had conversations with Mr. Wood about that phone call between Lori and Summer, and he's aware of it. He's expressed to me in a very human way his concerns about, you know, how emotional that was and how hard that was for my client. So I found this conversation substantially concerning because of that history. This isn't a normal case. This is a weird case. And that history behind it, it bears explaining.
Would you agree that this conversation, again, looking at the totality of the situation and the relationship and the emotional connection in which you have described, would potentially impede a truthful, straightforward testimony from Mrs. Shiflett, given the context of this conversation?
Your Honor, I'll object for speculation.
Your Honor, I think we have if I may respond.
Go ahead.
Thank you. We have a witness here who has 27 years of legal experience and was involved in this recording and has obviously had multiple conversations with Mr. Wood and Mrs. Shiflett and has a better understanding than I think any of us regarding the totality of this situation, including the recording and what was before. His prior testimony discussing the emotional connection of Summer and Lori, and then having a conversation of death penalty with and religious aspects of these type of things with the prosecutor, I think he's the person in the best position to offer us whether his opinion or not, or whether this might impede Summer's testimony. I think he should be allowed to answer the question, and then the court can weigh it for what it's worth.
All right. Well, the question really is whether or not this conversation would impede the witness potentially at some future hearing from offering truthful testimony. I think that does call for speculation, so I'll sustain that objection.
Thank you, Your Honor. Your Honor, I have no further questions for this witness at this time.
All right. Thank you, Mr. Means. Mr. Evans, cross-examination by the state in light of that direct examination.
None, Your Honor. Thank you.
All right. Mr. Pryor, do you have any cross-examination as it relates to
Mr. Smith, based on the discussion that took place between Mr. Wood, this wasn't an interview, was it?
No.
This was a narrative that Mr. Wood presented to your client, correct?
He did the majority of the talking, yes.
And the narrative that was presented was basically his ideas about how this case should proceed, right?
Your Honor, I'll just object. We've been down this road numerous times. we have the conversation, we've got the transcript. It just seems like we're hauling down old ground again.
I will sustain objection.
Do you believe the manner in which Mr. Wood discussed his theory and the facts of this case impacted Summer Shiflett?
Objection, again, speculation.
I'll overrule that objection if the witness has an answer.
Mr. Pryor, I'm sorry, you cut out partway through your question. I heard the objection and the judge overruling it, but I didn't hear the question. Could you repeat it?
The question is whether or not the discussion that Mr. Wood had with Summer Shiflett and presentation of his narrative impacted your client, Summer Shiflett.
I believe it did. Before I disclosed this, I had a discussion with her about why I was disclosing this, to get her authorization to disclose this conversation to another attorney. And she was in agreement with me doing that.
Okay. All right. No further questions, Judge. Thank you.
All right. Thank you. I think that concludes then the testimony of Mr. Smith. Mr. Means, you made some mention that, or Mr. Pryor, I don't recall, that you may want him still available for future testimony in this hearing. Is that correct?
It is, Judge. Thank you.
All right. Mr. Smith, I'm not sure what your day has in store, how long this hearing will be, but are you able to be available if we request to have you recalled in this matter?
Yeah, Judge, this is unique. Normally I would be in a courtroom and sitting out in the hall waiting to be recalled. Does that mean I'm going to go on mute, or I'm going to be unceremoniously kicked out of the room and admitted later? I don't know how, and I can do that, yes, or I could get a phone call or a text message saying, we need you again. I'm available, yes.
Judge, my preference would be that Mr. Smith, if needed, be contacted and asked to log back onto Zoom. I understand the constraints of an attorney and the time, so I think it's inappropriate to ask Mr. Smith to stay on, but if we need him, just see if we could get him back through a phone call or otherwise.
Okay. If you want to, we'll either put you back in the waiting room and you can just do other things, or if you'd like to just log off, Mr. Smith, then we will reach out to contact you at a future time. If
I'll log out. That's just fine.
All right. Thank you.
All right, thank you.
All right, Mr. Pryor, who do you intend to call as your next witness?
Judge, I would call Dr. James Davidson.
All right, why don't we start then with your examination of Dr. Davidson, and then at some point we will take a mid-morning break, but we can do that here in a little bit unless, Madam Reporter, are you okay, or would you like a break at this time?
No, Judge, I'm fine. Thank you.
Thank you. All right, so Mr. Pryor, if you'd like to commence with your examination of your witness.
Do you want him sworn, Your Honor?
Mr. Davidson, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in the cause now pending will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Sir, would you state your name and spell your last name for the record for me, please?
Yes, it's James Davidson, Davidson.
Dr. Davidson, how are you employed?
I'm in a private practice of forensic psychology, doing civil, criminal, and family law in various states.
Okay, and can you tell me a little bit about your educational background, sir?
I have a Bachelor of Science in Psychology from Michigan State University. I have a Doctor of Philosophy from Kent State University in Psychology. I have advanced family law mediation training from Southern Methodist University. Hundreds and hundreds of hours of continuing education in forensic psychology matters, and have also done training for continuing legal education as well as of other psychologists.
Can you give me a little bit of information about your prior experience as an expert testifying in litigation?
I've testified in several states. I'm going to restrict this to criminal matters just for simplicity, but testified in various states on mitigation in Idaho, 1925-22 examinations, 18-207 for mental status at time of offense, 18-11 for competency, and then general forensic evaluations when there may not be in the criminal code a particular test or structure for a report for an issue. I've done hundreds and hundreds of these in various places, done insanity defenses in states that allow insanity defenses. In Idaho, of course, it's one of 4 that does not, and have done this for probably now 30 years.
Okay. And you mentioned forensic evaluations. Can you elaborate a little bit on what is a forensic evaluation?
Forensic evaluation is the intersection of a legal issue and a field of study, in my case, behavioral health. And so in every state, if we look at criminal issues, a forensic evaluation will deal with a particular issue. So if you have a mental state at time of offense, it is the culpability or the ability of the defendant to rationally be able to understand the consequences of their actions from a mental condition. If somebody has pled guilty to a charge, the court may require or want to have a mitigation report. What's their risk of future violence? What's their mental condition? And that would be used in consideration of sentencing. So a forensic evaluation is going to be an evaluation that will rely upon 5 principal areas. It's going to rely upon interview, testing, observation, record review, and collateral information as a structure, with the nature of the report varying depending on the issue presented to me by the court or by an attorney who's retained my services.
So in other words, asking or an attorney asking you to conduct a forensic evaluation, this is somewhat of a specialized field. Would you agree with me?
It's a highly specialized field, and I would agree with you.
Okay, and in this particular case, this conducting forensic evaluations, have you previously been identified and qualified as an expert witness in offering your testimony and opinion in regards to forensic evaluations?
I have in multiple states.
Okay, and how many times would you believe, you don't have to give me an exact number, have you been qualified as an expert witness to offer an opinion after conducting a forensic evaluation?
I'll tell you that most cases don't require testimony. They are reports used for settlement, or settlement occurs, a plea bargain. But in the last 5 years, looking at, pardon me, civil requirements that I have a 5-year history of testimony, I've testified in over 50 cases.
Okay. So a combination of your educational background and your knowledge in doing this, your skill and experience, you believe that you're qualified to offer an opinion based on what forensic analysis you've been asked to perform. Would that be fair?
Yes.
Okay. Judge, I'm going to move for this witness to be qualified as an expert witness for purposes of offering his opinion in this forensic analysis that he's been asked to perform in this case.
All right, there's a motion. Is there any objection to that, Mr. Evans?
None, Your Honor.
All right, Mr. Davidson will be considered an expert under the rules of evidence and under Idaho Criminal Rule 16 for purposes of this hearing. Based on that, so Mr. Pryor, you can continue with your examination.
Now, Mr. Davidson, I do want to relay that you and I have not spoken about this case prior to this, you being hired. Is that fair?
That's correct.
Mr. Means hired you as an expert to do a forensic analysis in this case. Is that correct?
Yes.
And as part of that forensic analysis, can you relay to the parties in the court what steps you took and what information you had to prepare your report?
Well, the steps that I first took would be to understand what's the nature of the assignment. And in doing an assignment of this nature, I'm always approaching it from a standpoint of I know nothing, I have no prior opinion, and that my task is to provide an unbiased report as if I was appointed by the court directly. So given that, I was informed that the task was to listen and review a recording and a transcript of that recording to determine my impressions based on my experience and training of the nature of that conversation, whether there were any issues or problems, if that conversation was put into context as being a conversation prior to an interview of a witness in a criminal matter. So I listened to the recording. I also went through the transcript and reviewed the transcript. And then based on the training and research that I did concerning interviews in a criminal matter of a witness, formulated my opinions and observations about the appropriateness, the inappropriateness of whatever occurred in that transcript and recording. And out of that generated a report called a forensic analysis of Summer Shiflett's interview by prosecutor Robert Wood.
Okay. And that report was attached as part of a submission in this particular case. Is that correct? Or if you're not aware of that, that's fine.
I didn't actually submit it. I turned that report into Attorney Means, and I'm sure he submitted it in whatever fashion he did.
Now, I would like to talk about the type of models that are used and how that affects your decision in this particular case. Can you discuss that with me a little bit?
Sure can. Interviewing any witness is an area of great concern because historically, going back decades, interview techniques have been highly prejudicial and biasing and have led to problems such as false testimony. It's led to omission of facts in testimony. And so over the years, internationally, there's been efforts to come up with various models of how to interview a witness to obtain as best as possible untainted, spontaneous information with a really fine grain of detail that would describe what that witness has to offer in testifying about a case. So I have listed in my report, and I'll just run through it very quickly, examples of very prominent models, both in this country and particularly in the United Kingdom and its those in this empire. There's the access model, which is an acronym that stands for assess, collect, collate, evaluate, survey, and summarize in interviewing a witness. There is the ABE model, which is in the United Kingdom for interviewing children, achieving best evidence. There's a conversation management model, which is based on the elements of reciprocity, response, and a managed sequence of greeting and orienting the interviewee. There's the peace model, which is used in the United Kingdom and Canada. And the peace model is one that's inquisitorial, but not confrontational or accusatory. And that came about because of issues that they'd had in prior criminal cases of prejudiced and tainted information in high-profile cases. There's the NICHD model. This is a model used particularly when there's allegations of abuse of a child or an adolescent. And it's a model that emphasizes elements that is common to the other models, such as open-ended questions. It emphasizes having a narrative to establish a robust level of testimony from an interviewee. It also establishes the fact that a person is going to offer to tell the truth. There's a Wicklander-Zulawski model, which is particularly used more in business, but it has the same kinds of elements to avoid civil litigation, where there's an emphasis on non-confrontational narrative rather than confrontational and a conversational approach to try to developing information from a witness. And then the granddaddy of everything that really spawned a lot of these models that attempt to get high quality, reliable information from the court is the Reed model, which goes back to the 40s and the 50s, which is used in criminal investigations where there is theoretically initially an interview of a potential suspect that turns into an interrogation. And the Reed model is one that has a lot of critics because it had and has become at times highly prejudicial in its techniques of refuting whatever a person would say in the interrogation if it doesn't line up with the theory of the investigators. So those are an example of various models that have been developed. And just parenthetically, those models were developed because there had been cases in various countries of people that were convicted only to find later that the evidence and how it was obtained and the way it was presented had prejudiced what people had to say, leading to convictions inappropriately of various people, going back to very, very publicly going back to the 70s.
Now, talk to me a little bit about the idea of best practices.
Well, best practices obviously is going to be in the eye of the beholder, but we know in the legal world that you have restrictions on how you can ask questions and the nature of the questions, and that you have to lay foundation to bring evidence into play into a court proceeding. We know in the behavioral health world that how questions are asked can lead to different answers. And so the effort in best practices is to codify as aspirational practices. What do you do to interview a person to get high quality information that avoids manipulation, that avoids suggestibility, and it avoids coercion? And in doing that, best practices, there's an effort to keep bias out of it, which is inherent in any interview. There's an effort to have it be fair. There's an effort to have the interview's information not be derived from closed-ended questions, leading questions, but open-ended to hear what do they have to say and develop that narrative robustly. There's an emphasis in best practices to have basic principles in play, that a person would act ethically. When I do forensic interviews, I'm doing it as a member of the American Psychological Association, also as a licensee in 7 different states. If I'm a lawyer, I'm doing under the American Bar Association and the Criminal Code of Conduct in a particular state. So ethics are important. Integrity is important because in a criminal case, we're trying to determine whether there's a level of guilt beyond a reasonable doubt. And that is based on testimony, where we're looking at people telling us the truth, acting honestly and with fairness, and in doing so, not manipulating information. So we have really an integrity issue that's important in best practices. We also have in best practices avoiding inappropriate interviewer behavior. Efforts to interview should not attempt to influence, exploit, shape, or misrepresent what a person has to say. And so, for example, you would not ask in the case of an abuse situation, tell me where they touched you. You would start off with asking, tell me what happened, and maybe nothing happened. So you can see very easily how a question could influence the response of a person. In best practices, we're looking at being sensitive to vulnerable witnesses so that there's not any sense of undue influence. Vulnerable witnesses can be people with cognitive difficulties, emotional difficulties, people that are emotionally highly engaged or tied into a matter, people that have age issues, that have issues of fatigue. Sometimes there's cultural issues. And so with a vulnerable witness, it's very, very important that the level and the professionalism in the interviewing be at its very, very best, to avoid misunderstanding and avoid having a person be misled and guided in their testimony rather than offering unfettered, free, and accurate testimony. And best practices, just to wrap it up, typically there's an opening procedure that goes by the mnemonic of GMAC, where we have a greeting, we have an explanation, we have a definition of the mutual activity. We're going to do an interview on such and such. This is how we're going to do it. And then a closing, thanking somebody for appearing. So best practices are anticipated and expected. And certainly in a case where there would be, from a forensic psychology standpoint, a forensic interview, if I did not conduct that interview, for example, in an allegation of abuse by NICHD standards, which are similar and identical to what's used in a child advocacy center, my testimony should rightfully be challenged. If I interviewed an adult and I'm doing a mental state at time of offense or an insanity plea, my interview needs to be done as neutrally as possible because I'm retrospectively trying to determine what that person's mindset was 6 months, a year, 2 years in the past. So the best practices is pivotal in any of the activities that involve interviewing of people in a forensic setting.
And to follow up on your response, best practices also involves not invoking any bias or feelings or prejudice to someone that you're talking to about a particular case. Is that fair?
I don't think, yes, it is fair. I don't qualify it in saying that in any situation, there's always some amount of bias, and it's difficult because if you're the person doing the interviewing, it's hard to see the trees for the forest. But yes, to minimize bias is critical.
Now, you had an occasion in this case to review the tape recording that Mr. Means provided to you. Is that correct?
I did.
And you had an opportunity to review the transcript that's been admitted as, I believe, exhibit number 1 in this particular case. Is that correct?
Yes.
And as part of that process, you prepared a report, approximately 24 pages, detailing your findings in regards to that review. Is that correct?
I did.
And based on your experience and knowledge in this case, and having testified numerous times, you came up with some conclusions regarding and findings regarding this tape recording. Is that fair?
Regarding the narrative on the recording, I did.
And before I start, I guess I want to clarify something. You're aware that this recording took place. Would you describe the interaction between Mr. Wood and Ms. Shiflett in the first 18 minutes as an interview?
No, not at all.
What would you describe it as?
I would describe it as a session or a meeting where the witness was obviously being greeted for the first time to educate and inform the witness of the prosecutor's perspective, theory on the case, and to elicit the participation of the witness in that theory of the case.
Okay. And Judge, I have a lengthy discussion that's going to take place with Dr. Davidson. I would ask if the court wants to take a break at this time before I engage in this lengthy discussion regarding his findings, or would the court like me to proceed? And I will defer to the court's wisdom.
I think this would be a good time to take a mid-morning break, so we'll do that. Before we move on, there was one concern I wanted to address there with Mr. Davidson. Mr. Davidson, in offering your testimony here, are you have you been reading from or referring to anything outside of just your own memory here? I had a concern.
No, I have reviewed carefully my report, Your Honor, but I'm operating on my memory in preparation for this hearing.
Okay, understood. I just want to be, it's a little concerning when we do these Zoom hearings that everybody's on a computer, but we don't always know what's there. So I just want to make sure you do testify. If you are referring to something, we need to put that on the record and know what you're referring to and give an opportunity for a possible objection. So keep that in mind as we move forward with your testimony. With that said, why don't we take a break for about 20 minutes? So let's plan on starting up again at about 10 after. Is that okay with everyone?
Yes, Your Honor.
Yes, Your Honor.
All right, thanks, counsel. We'll come back on and continue this hearing at 10 after. All right, I think we've got everybody back. Madam Reporter, are you ready?
Yes, sir.
Okay, Madam Clerk, are we ready?
Yes, Your Honor.
Okay, thank you. We'll continue with the Mr. Pryor's examination of Dr. Davidson. I'll remind you, Dr. Davidson, you're still under oath. Mr. Pryor, you can continue your direct. You're on mute, Mr. Pryor.
Dr. Davidson, as part of your analysis and evaluation of this particular case, you prepared a report, is that correct?
Yes.
And that report is 24 pages and it's been signed by you, and my understanding is it's been provided to the court by Mr. Means, provided to Mr. Wood, provided to me as well. Judge, at this time, I'm going to move for admission of Dr. Davidson's report as an exhibit.
First, we need to have it marked. That would be Exhibit 3, I believe.
Oh, I'm sorry, Judge. I thought it had already been marked. I apologize. So I have it down as exhibit number 4, but if the court wants to put that down as exhibit number 3, that's fine.
We can use whatever number you want, Mr. Pryor. I don't know. We've had 1 and 2 admitted, so I was just
Let's stick with, as the court suggested, exhibit number 3 and have that marked as exhibit number 3, and then I move for admission of the exhibit.
All right. The report of Dr. Davidson dated December 31st is marked as Exhibit 3. Is there any objection to the admission of the report? Mr. Evans?
No, Your Honor.
Okay, then by the exhibit is admitted, exhibit number 3, and that is Dr. Davidson's report.
And may I proceed, Your Honor? Judge, may I proceed?
My apologies. Yes, you may, Mr. Pryor.
Thank you, Judge. Dr. Davidson, I can't have you look at your report while you're testifying, but at any time during this process that you feel that you need your recollection refreshed, I would ask you to pull out your report, review it, and then when you are done, set the report aside after your recollection has been refreshed, and then testify on that refreshed knowledge. I assume you've been through that before, but do you understand that, Dr. Davidson?
I do.
Okay. So Dr. Davidson, I'm going to start at the beginning of your report, and that's on page 7 of the report. And Judge, the difficulty with this Zoom is unfortunately I may have education experience, 25 years of doing this, but technological experience is incredibly limited. So I don't know how I can get the report on the screen, but I will refer by page number and paragraph, and I believe all the parties have that report, if that's acceptable to the court.
That would be fine with me. I do have a copy I can view here.
Okay. And Dr. Davidson, do you have a copy of your report with you?
I do.
Okay. And again, I do not want you to look at the report while you are testifying. If at some point you don't have a clear recollection of what you put in the report, advise me, and we'll go through the process of refreshing your recollection so that we follow the rules as they are set forth that we're guided by. Do you understand that?
I do.
Okay. So Dr. Davidson, on page 7 of your report, you started out with the first statement that Mr. Wood made on the recording. Everyone is kind of running down the kid's case because they were last seen in Rexburg and you were living in Rexburg, and then there's some narrative after that in your report. You made a conclusion based on that narrative where with the last statement being that we are going to be filing conspiracy to commit murder charges against both Chad and Lori. And what was that conclusion you made after listening to and reviewing that narrative?
It's going to be difficult to recall these pieces on such a micro level. Do you want to tell me a little bit more about the narrative, or?
Well, I would have you refer to page 7 of your report, Dr. Davidson.
Give me a second. Got it.
And if you would read the middle of your page of your report where it starts with Robert Wood being highlighted and read down to the words Garrett, okay.
Okay, so I don't have anything highlighted in my report, but are you talking about Robert Wood with Tylee was last seen? Or
Yes, and you made a conclusion at the end of your report, you made a conclusion with a check mark.
Exactly.
So what I need you to do before you testify is review your recollection of that finding that you made, and then set the report aside and then testify.
What I'll do is I'll just make it as clear as I can. I'm doing a quick scan and here's my finding. And if that's inadequate or troublesome, any of you can let me know.
Okay.
So looking at that, scanning that information, the conclusion I had was that this would be a type of bias that I call inner circle bias.
Okay.
And inner circle bias is a situation where a witness is provided with information that's not known to the general public. And so it's an effort to include the witness in sort of the inner circle of information. And as a result, it can be co-opting of that person to really join whatever that inner circle is. So that would be the bias that I believe was active in that particular interchange.
And the interchange is where he talks about seeing the kids in Yellowstone, and then his decision of telling Miss Shiflett that he's going to file murder charges against Chad and Lori. Is that correct?
That's correct.
And co-opting, talk a little bit about the co-opting.
Co-opting is, it can be very, very obvious, or it can be very subtle. But co-opting is the manner in which you kind of pull a person into your viewpoint. So for example, just as a totally different example, because earlier I mentioned abuse, we could talk about how, say, everyone knows that people that abuse children really are pretty bad, right? What you should know here is that we have information to that effect. So what I'm doing is I'm informing someone and also kind of setting the expectation that they would align with me in my group that would be opposed to whatever the other group does or is.
So when you're talking about groups, what you're in essence saying, and correct me if I'm wrong, Doctor, is that the statement by Mr. Means to express to a material witness that in the future these charges are going to be coming, it's his attempt to bring that witness to his side and basically push the other side, i.e. the defense, away. Is that fair?
Objection, Your Honor. Counsel's testifying.
Saying that objection, I think it also misstates you. Indicated Mr. Means had said that, so why don't you re-ask the question in a different way?
When you're talking about dividing the particular parties, the bias you're talking about is for the prosecuting attorney to bring him, or to bring Summer Shiflett into his side of the case. Is that fair?
Your Honor, again, counsel's testifying.
Okay.
This is a direct examination, not a cross.
What's the purpose of the bias?
Mr. Pryor, I'm not done with the objection ruling, so I am sustaining the objection.
Oh, I'm sorry.
Another question.
What is the purpose of in this particular case specifically, bringing a witness into the inner circle?
Well, I would have to speculate as to the purpose, because I don't know the prosecutor's purpose. I'm just identifying the nature of the bias that's involved, which is what I would call inner circle bias.
Okay. And is this inner circle bias, in your opinion, an attempt to influence a witness?
It could be construed that way. Again, I don't have the purposefulness behind it from, in this case, of the prosecutor, but whether it's intentional or unintentional, that bias can have easily that consequence. That's why it's called a bias.
Okay, so it's not a matter of whether there was an attempt to influence a witness, it's whether it was purposeful or unintentional. Is that fair?
I don't think I can speak to purpose, what I'm trying to say here is to back up earlier to my testimony. Best practices argues to minimize bias in any form because it can lead to intentionally or unintentionally manipulation, coercion, setting expectations for how somebody would testify and so forth. And so inner circle bias is going to be a type of bias that will try to, again, inadvertently or advertently, draw that person into the inner circle, align with the person's inner circle and their viewpoint and the scope of what they may speak about or testify to.
So I need a bit of a clarification. When you're talking about someone drawing someone into the inner circle, you're talking about the person who provides that information and you are sending that message to someone to draw them into your inner circle.
Correct. It's initiated by the questioner or initiated by the person who is taking the lead in a meeting, and the effort is to draw them into that person's circle, not the witness's circle, but in this case, a prosecutorial circle.
So when Mr. Wood comments that he's going to bring these murder charges against Chad and Lori, it's your position that that could be construed as Mr. Wood trying to draw Summer Shiflett into his inner circle.
I would probably not necessarily say that with the example you gave. I would probably say that that would then become a statement that would likely very much alarm a witness and have them wondering, what do I do to avoid that potential charge?
So in other words, go ahead, I'm pleased.
Well, I don't think that would draw somebody into the inner circle of I'm advocating for a capital charge.
Okay.
I don't think that would be the impact of that particular statement.
Okay, so what you're suggesting, and please correct me if I'm wrong, is that that statement that statement would have the impact of causing the person, in this case Summer Shiflett, to offer information that would avoid that consequence.
That would be a good possible conclusion, yes.
Okay, all right. Let's move on to the next part where it starts with Garrett okay on your report on page 7. And if you would read down to the bottom of page 24, I would appreciate it to refresh your recollection.
Okay, let me look real quick. So it says Garrett okay, Robert Wood, and we're not shy about that. We've told both attorneys. His attorney keeps pretending like I've never said that. You want me to read it out loud like I'm doing?
By all means, if you want to, that's fine.
Okay. And it says what? But we have to. But I kind of want to give you a little bit of background of where we are and kind of our theory of how this ended up where it was. We know that this is not the same Lori everyone else knew. What's so strange to me is everyone we talked to who knew Lori before this, she was primary president. She made quilts for these kids. She made everything fun. Everyone loved her. She loved everyone.
Okay. And then you come up with some comment with a check mark. And if you would read that comment and then set it aside and tell me what your analysis is in that regard.
Well, to the bottom of 24, there's one comment and then 2 more in the top of 25 that are related to that passage.
I wanted to do it one at a time just so we didn't become confused.
So at the bottom of 24 that says best practice mutual activity. The mutual activity of listening to this witness has yet to occur. The prosecution is actually testifying to the theory of the case, which risks influencing the witness narrative. No open-ended questions or active listening has occurred. The task of interviewing the witness is trumped by case information.
What do you mean by that then?
Well, what I mean is the stage is being set here for the prosecutor informing the witness of the purpose of this meeting, that we're not getting into questioning her or just welcoming her to the day of questioning later in the interview. What's happening here is the mutual activity, the reason we're here. If I start only with this piece, the reason we're here is to understand better my viewpoints as a prosecutor of the theory of the case and what I'm anticipating or expecting your reaction might be to that. So the mutual activity for a person who came in for an interview as a witness is quite different in this meeting. It's not a mutual activity as being interviewed as a witness. Mutual activity is to be informed of the theory of the case.
Okay. And then you go on the next page, which would be page 8 of your report, and you talk about bias. And would you review that provision and then be prepared to testify about what you mean by that?
Yes. Give me 1 second. Sure, I'm ready to go with that if you'd like.
Okay, let's talk about the bias and the derogation.
Well, the derogation comes with the extracurricular comment about the defense attorney. The defense attorney is not listening, for example. And so when you have a person who has great influence over the proceedings, the prosecutor in this case for the state, when they derogate the defense attorney, what's happening is really a not so subtle statement that this person should be really disregarded. This person is not a person who carries any real weight. They're just not thinking clearly. And the impact of that, if I'm a potential witness, now is to have to determine, well, whose side am I going to be on? And who do I really listen to? Since we've had clarity on things like death penalty, who do I really want to try to speak to? Because apparently the other person, the defense attorney for my sister, is simply not with the program.
Okay, and then you went on to talk about in-group versus out-group in your report. Explain that for me, would you please?
Right. Well, the in-group and the out-group, again, is, in this case, the prosecutor, in providing the theory of the case, is letting us know that his group is the in-group. This is why there is this education on his theory of the case. The out-group, with the incompetent or the clueless defense attorney, if you will, is the other group. And that happens to be the group that I mentioned before with derogation. So when you have an in-group, out-group bias, what you're really doing is you're laying the foundation or the seeds for a witness to be able to decide, who are you going to really align with? The problem is, if we go back to best practice, they shouldn't align with anybody. The focus should have been, what do you have to tell us that's reliable for this case and the information pertaining to the case? What's your information? Not what is your alignment.
Okay. And the next paragraph, it starts with Summer Shiflett saying, "Great mom." Mr. Wood makes a comment, and then you come to a conclusion as well. Would you take the opportunity to refresh your recollection on that paragraph, and then let me know when you're ready?
Okay, just a minute. Yeah, I'm ready.
Okay. So Summer Shiflett makes a comment that says, "Great mom." Mr. Wood makes some comments. If you would be so kind as to read Mr. Wood's comments.
Great mother, that's what everyone says, and you know. So one thing I'm going to ask of you to consider is maybe something happened. I don't know what. I don't know if it was psychological. I don't know. I don't know if we'll ever know. But something happened, and I think Colby, the way he said it to me, I think, is kind of the person who is in that jail cell is not my mom, it's someone else.
Okay, so you came to a determination, and there's a check mark in your report in the middle of page 8 that says bias. Would you explain your analysis?
Yes, confirmatory bias is what I noted, and confirmatory bias is when a person presents information selectively to confirm their viewpoint of something. And so in this particular case, the viewpoint that's being presented and confirmed is Well, it looks like she's involved, but she's a different person. She's someone else. And so we have here an example of confirmatory bias where we have an evaluative statement about the defendant by the prosecutor to a witness before that witness has been interviewed. That's a problem.
Okay. Does that rise to the level of trying to influence a witness?
Well, again, that's going to be a matter of my determining purpose. But if I can slightly modify your question, I would say, can that lead to influencing a witness? Not, was that the purpose of it? Yes, it absolutely can lead to influencing a witness. It is not a best practice approach.
Okay, and is this ever an acceptable practice in interviewing a witness? This confirmatory questioning in this way?
I'm only smiling because in a bad read technique interrogation, the answer is yes, but this is neither in that situation at all. So the answer is no, this is not appropriate. You're trying to get untainted, raw information that's reliable from a witness about a case. This is not that example.
Okay, so this is actually an example of trying to taint the information you're getting from a witness. Is that right?
It would be an example of that, yes.
Of tainting a witness's testimony.
Correct.
Okay, let's move on where it says Summer Shiflett, yeah. And that's in the middle of page 8 of your report. If you would be so kind as to review the rest of page 8. And actually that would go through to the bottom of page 8 just before it says Summer Shiflett.
Okay, I'm ready.
Okay. Why don't you state what Mr. Wood said, and it starts with the flip side.
The flip side of that is, I shouldn't say the flip side, but I want to be clear. I'm not going to pull any punches on any defendant in this case, right? I've got my job to do. And Summer Shiflett says, absolutely. And Mr. Wood says, but we also want the truth and the whole truth and the context of it. And Chad Daybell is, did you ever meet Chad? And then at the bottom, Summer Shiflett of this page says, so I met him once at a preparing people. I went to one preparing people thing.
Okay. And then you, between the Summer Shiflett and Mr. Wood, you talked about acquiescence and bias. Would you elaborate on what your finding is in that regard?
Right. One method of bias, or one aspect of bias called acquiescence, is when you ask questions in such a way that you elicit confirming responses or negative responses from the person that you're talking to. So as an example of an acquiescence, it would be like, you met this person, correct? Yes. They aren't very nice, are they? No. So you would ask questions where this person's agreeing with the questioner. And that acquiescence, if it continues across an interview, really shows a shaping of the testimony or the nature of the reply from the interviewee, rather than an open-ended, neutral kind of investigation. So in this particular case, I'm saying that there's acquiescence because the first beginning of the pattern is she says absolutely.
Okay. So is this a situation again where the witness testimony may be manipulated or influenced by this acquiescence?
The nature of the questioning, if it's repetitive and leads to acquiescent responses, does shape the nature of that person's testimony.
Without a doubt?
Well, there's always doubt, but that's why we would use open-ended questions, because it doesn't demand a yes or a no or an absolutely or a never. It just requests a narrative. Here we have questions that are demanding a yes or a no, or the person's volunteering it, which goes back now to in-group and out-group kinds of bias, because they're confirming I'm in your group.
Okay. And by her comment, absolutely, and throughout this report, Ms. Shiflett is confirming that she's in Mr. Wood's group.
By the time you get done with the report, that's correct.
Okay. Now, you noted in your report on the last line of acquiescence bias that this pattern of witness acquiescence repeats throughout this interview. You saw other instances where Mr. Wood and Ms. Shiflett engaged in this bias acquiescence. Is that fair?
Yes, I literally went through and at one point actually counted the number of acquiescent responses. I don't recall a number, but yes.
And was it numerous?
It was almost 100%.
Okay. So then you went on to mutual activity best practices in your report. Would you explain that for me?
Yes. She's present voluntarily, in my understanding, to be interviewed. So we actually have an interview question, but it is a closed-end question rather than open-ended. Do you know Chad Daybell? Yes or no is the answer. And the activity then that begins to be defined is A, I want to educate you on the theory of my case, and B, if I'm going to proceed with questioning, they're going to be closed-end questions instead of open-ended questions.
And in this particular case, this wasn't so much a pattern of asking questions as it was a dissertation of his Mr. Wood's opinion of the case. Is that fair?
That's correct. There's literally, this is the only question that was asked.
Right. Okay. So let's move on with your report to page 9, if we could, sir.
Okay.
And if you would read the first part of page 9 and stop after your analysis where it says Summer Shiflett.
So you want me to read it out loud again, or just?
You don't have to read it out loud. If you want to read it to yourself, and then we can talk about it and do your analysis to each section.
I know it's in the record. Sure. Give me 1 second. Okay, I'm ready when you are.
Okay, so at the conclusion, Mr. Wood says, okay, of course he said that. And then you come back with your analysis in the report that says best practices mutual activity. Would you explain your analysis in that particular part of the discussion?
Well, yes, it's defining what the mutual activity would be if we have questions, which is I ask you a closed-end question, you give me an answer, yes or no, or something similar. And by the way, you'll notice that there's no follow-up to it. So we have questioning here, which is not really eliciting a response about the witness's opinion on things. It's actually eliciting a response to the questioner's opinion on things. What do you agree or disagree with what I just said? Do you know or don't you know? And that, again, in terms of best practices or having an interview, is not a best practice. This taking place before the interview is also not a best practice, because it's really developing a mindset about what interviewing would look like. That's why I say we have a mutual activity problem.
And I want to elaborate on that a little bit. Quite honestly, when you say it's not a best practice, the interview, and you didn't go over the interview by the police with Summer Shiflett, but what you're suggesting, correct me if I'm wrong, I want a clarification, is that the discussion that Mr. Wood had with Summer Shiflett prior to the police is what you're referring to. Is that correct?
Yes.
And that discussion that Mr. Wood had with Summer Shiflett prior to the police is troublesome. Would you agree with that?
Well, that's my conclusion, yes.
Okay. And it's influential, is it not?
I believe, based on the responses that I saw in this particular 18 minutes, that yes, it was influential.
And it would have an impact on Summer Shiflett's testimony. Would you agree?
I think it likely would.
Okay. Let's move on with the rest of the report that we spoke of. And you talked about, after Mr. Wood said, okay, of course he said that, best practice is mutual activity again, or I'm sorry, bias stereotyping. Would you discuss your analysis in that regard?
Well, this is stereotyping the other defendant, because of course he said that really is a gratuitous statement that says, what would you expect, from this person? So from that standpoint, I would say that it is a stereotypical comment. And much like we have the derogation earlier of the defense attorney for Ms. Vallow, here we have a stereotyping of the other defendant as a person who would, of course, say that. And in those regards, if I'm a witness hearing this, I am now getting taught how I should think about both of those people.
Okay, and then we move on, and there's a couple of statements, or a statement by Ms. Shiflett, Mr. Wood. In essence, the comment is, welcome to Chad Daybell, and you put down best practices, mutual activity. Explain that analysis.
Yes, it's really the same thing. The mutual activity is the purpose of our meeting. Our mutual activity here is to understand on the cast of characters and the theory of the case, who's bright, who's not bright, who's bad, who's not so bad. You know, who carries greater culpability, who really does not, who was a better person at one time, who was not. So we have here a shaping, if you will, of what people's roles are, and that's why I call this a mutual activity bias.
Okay, and this mutual activity bias could be understood to mean that you're trying to influence a witness again. Is that correct?
It could, yes.
Okay, let's go down to the next analysis, which is bias confirmatory at the bottom of page 9 of your report.
Okay. Well, the confirmatory bias that I'm referring to here comes from a statement that is an influencing statement. So what I want by the prosecutor is a statement. That leads to a person either ignoring the statement, denying the statement, or affirming the statement. And in this particular case, as I recall, she initially tends to deny it, but then with one or more comments from the prosecutor, she basically acquiesces.
Okay, so in other words, in your opinion, initially denying the statement, denying this, and then acquiesces, that means she changes her statement to the prosecutor after he prompts her with some narrative. Is that a fair analysis?
That's absolutely correct.
Okay, and that would be construed as coercing a witness. Is that fair?
If we can put that in context of coercion is on a spectrum. So it can be anywhere from a nudge to a push off of a bridge. And depending on what the prosecutor says here would be somewhere in that spectrum, if you wanted to look at it or not.
And in that spectrum, it still constitutes coercion of a witness, does it not?
Your Honor, objection asked and answered.
Same that objection, it was asked and answered.
I'm sorry, Judge, I didn't hear your response.
The objection sustained.
All right, I'll move on, Judge. That's okay. Then if you would be so kind, Dr. Davidson, to read the bottom of page 9 and the top of page 10 of your report, and then we'll get into the analysis of those statements as well.
Okay, got it.
Okay. If you would be so kind as to read Summer Shiflett's statements and then Mr. Wood and go through that so we have a context of what we're talking about.
Sure. On the bottom of page 9, Summer Shiflett, I have my own opinions for him. Don't get me wrong. Robert Wood, I bet you do. He is highly manipulative. Summer Shiflett, yeah, he is. Robert Wood, I'm not going to say he's highly intelligent, but you don't have to be highly intelligent to be highly manipulative. Summer Shiflett, absolutely. Robert Wood, he is extremely manipulative, pardon me, and your sister manipulated him in some ways too, but the context for everything that happened came from Chad.
Okay, so your analysis starts with best practices, mutual activity. Would you explain that analysis?
Yes, again, as you can see as this unfolds, the nature of our purpose of being here together, the mutual activity, keeps getting refined and defined. And so in this case, when she says, I have my own opinions, he responds not in telling or asking, well, tell me about that. He responds, well, I bet you do. And so we really have here a statement that says, to me, I bet you do means I'm not really terribly interested in pursuing that. I told you what I was interested in pursuing in what I just said to you earlier here. And so that's the mutual activity that we're talking about, defining and refining the scope of what the purpose is.
Okay, and then bias confirmatory is your analysis based on what you previously read. Explain that to me, would you please?
Right. So what we have here are statements to the witness about the nature of Chad Daybell. He is not highly intelligent. He's manipulative. He's very manipulative. This really is something that all came from Chad. So we have a qualification. Some of it may be from Lori, but it all came from Chad. So we have a layout of statements that either can be confirmed or not be confirmed. And in this particular case, as you'll see in the narrative that developed, the next thing that occurs is she confirms that statement. So it's a confirmatory bias. This is what I believe. This is what I want to hear from you. Yes or no answer. You agree?
Okay. All right, and then let's move on to the middle of page 10, where it says absolutely, and then Mr. Wood, unfortunately, and if you would be so kind as to read those as well.
Summer Shiflett, absolutely, responding to what I just described were statements about Chad Daybell. And then Robert Wood, unfortunately, we have enough evidence to prosecute him, and we are. The case against your sister is stronger, but I kind of want to give you just that background. That's the kind of context that we see this guy. This guy came in here and, not making excuses for anyone, but kind of blew up this situation, and he did not care who died.
So you talk about mutual activity best practices.
Right.
What's going on there?
Well, what's happening is he's just further developing the narrative on his theory of the case. And in developing the theory of the case, depending on the response of the witness, Summer Shiflett, we're going to see whether or not she acquiesces, the impact that it has on what she has to say, and so forth. Again, we are miles apart from a meet and greet about, I'm glad to meet you. Here's the purpose today. You're going to be interviewed by, have a nice time in town. We have here a full-blown exhortation on a theory of the case with her sister and charging and so forth hanging in the balance.
Okay. And in your comments, you say that it is apparent the prosecutor is in control of the narrative and there is little interest in the witness information. Would you elaborate on that for me, please?
Well, yes. He's not asking for any information. And when there has been disagreements, like I mentioned before, I bet you have, or things to that nature, they're really just shut down. Here, we have a situation where he's laying out his narrative and not asking anything about her viewpoint, which he would testify to, and how she perceives things. It is his narrative that is controlling this conversation.
Okay. All right. And I would actually then ask you to start with the Summer Shiflett, and then you have best practices analysis. And if you would be so kind as to recite that narrative as well, so we know what we're referring to.
Summer Shiflett, responding to the previous narrative, says, Robert Wood continues, who got hurt? And that's an extension of a sentence. And he did not care who died, who got hurt. He did not care at all. And this is Robert Wood. And the other thing I can tell you is your sister truly believes that everything she's done has been done in righteousness. Summer Shiflett says, I know. Robert Wood says, I know I'm kind of using LDS speak. And then Garrett, an attorney, says, yeah. And then Summer Shiflett says, 100%. That's my interpretation also. I think she 100% believes.
Okay. The term LDS speak, the reference to LDS speak, what is the significance of that statement?
Well, it's an inclusionary statement about a person's religion. The Latter-day Saints of the Church of Jesus Christ, more colloquially known as the Mormons. It's a alert to the witness that I can speak this language. And it becomes apparent as the narrative unfolds that the witness is very religious and is oriented towards the LDS faith. And the prosecutor has alerted her to the fact that he is as well. He brought it up, she did not.
Okay. And what he's saying to her basically is, I speak the same LDS language you do. Is that fair?
Yes. And that somehow is relevant, or should be relevant, to the nature of our relationship.
Okay.
Otherwise, why would you bring it up?
Okay. And then you go down with your evaluation of best practices mutual activity. Would you elaborate on that?
Well, what's happening now is as we refine and define the purpose of our meeting, what we have is a religious component to it now. So not only am I looking to see if you'll confirm the theory of my case, but I want you to know that I have the same spiritual beliefs that you do, and that's going to potentially be relevant to how I interact with you, and maybe even relevant to how this case proceeds.
Okay. And then you talk about religious bias on page 11 of your report.
Right. So religious bias is when a person brings into play a factor. In this case, it's religion. It could be another group that somebody belonged to, and just have a slight change of what the bias would be. But when you have a religious bias, the purpose of the religious bias becomes, again, one of shaping potentially the testimony and the outlook of that particular witness, as well as including them now in the in-group. By the way, I also share your spiritual values. That's a new in-group. That's another in-group. And we have now language which, to a person who would not be oriented to the Christian world, we have the term righteousness. And so now we're beginning to speak about terms that are on a completely different planet than the legal issues involved. Okay.
And you put some comment in there about adhering to the tenets of her faith. What did you mean by that?
Well, this goes to an in-group, out-group issue. And the issue is, if somebody is a believer, a supporter of their faith, not a nominal believer where, yeah, of course I believe in X, Y, Z, but somebody who adheres to the tenets or the principles, the ground rules, if you will, and the beliefs that are codified for a religion. And the Latter-day Saints have highly codified beliefs, just like any major faith would have. So now when we have the tenet of faith coming into play, now we have a concern. For some reason, the LDS aspect has been brought up. Now, if I'm a witness, do I simply testify about what I have to say, or am I somehow supposed to conform any of what I say to my spiritual beliefs? This is a little confusing. Now, I'm not speaking for what Summer Shiflett thought, nor what Robert Wood intended, but I'm saying that would be the typical consequence. We bring up an extraneous piece of information that has strong principles attached to it that originally were not part of this discussion. We just wanted to know what you had to say about the case. Well, now when we bring up this extraneous information as a witness, what do I do with this? There seems to be an underlying expectation, and I had not anticipated this. Am I even more so in the in-group because we share the same faith? And what does that mean? Or what? That's how I would perceive this. And again, we have language like righteousness, which also tends to undergird the whole thing.
Okay. And if you would be so kind as to start with Robert Wood, she believes it, and recite that narrative, and we'll get to your analysis on that section of the recording.
Robert Wood, she believes it. Summer Shiflett, Robert Wood. Every once in a while, you'll see kind of a little crack in like a jail phone call. Or she'll, and Summer Shiflett says, well, you've heard our conversations too, you know, that I get that she's not fully aware of what she's really done. And then we have Robert Wood, right, yeah. And Summer Shiflett, I don't think she is. And then Robert Wood, yeah, I mean, well, I'm going to say this. I think she knows what she's done.
Okay, and then you come in with best practices and mutual activity. Explain your analysis there.
Well, what we have here is Summer Shiflett saying, I don't know if she's knows like, you know, exactly what's gone on here. And the prosecutor is actually informing him not only of the theory of the case, but presumably a testimony that he'll be able to elicit that says she knows what she's done. You know, in fact, she knows what she has done. And that when she says, I don't think she is, he's countering that. So again, we have the refining of the mutual activity group. You know, what are we doing here? What's the purpose of today? And part of the message now becomes, well, you know, if you want to be in my group, you need to know, I know that she knows what she's done. And I'm not interested in you going and saying to me, well, I'm not sure she does. Plus, we have revelation of information that I would presume is not publicly available as well.
Okay, so the read technique is a technique in which when you don't agree with what a witness is saying, you engage in this technique to influence the witness to change her thoughts on what she's suggesting. Is that fair?
That's one component of the read technique, and specifically the read technique basically is if you say something that is not in line with the theory of what we want to hear, we will interrupt you or we will counter what you have to say. We will not allow you to develop that train of thinking or that line of testimony. We will block it. And you see here subtle and not so subtle versions of that.
And in this particular case, do you have any doubt that this read technique was used by Mr. Wood in the paragraphs you just read?
I would have tremendous doubt that he used a read technique per se, because I don't see enough of a cohesive technique on anything here. I see more probably a personal style. I don't even know if he knows what the read technique is. I know he's a prosecutor, so I wouldn't be surprised. But the read technique is more oriented toward educating police detectives, police officers on interviews and interrogation. But the process of what you're seeing is consistent with aspects of a read technique.
So in other words, he may not be completely aware of what the read technique is, but he adopted that process in dealing with Summer Shiflett to change her testimony. Is that fair?
I'm not going to go to his purpose of trying to get her to change her testimony. I will go to agreeing that he's using aspects of the read technique, knowingly or unknowingly, that have the negative effect of biasing or eliminating and changing a witness's testimony.
Okay, so let's go on to the next part of page 11, where it says Summer Shiflett, and if you would read that.
Starting with, she knew enough to lie to us about it?
Yes.
Okay, she knew enough to lie to us about it. And then Robert Wood says, right, yeah, but the context under which it was done was this, religious. Not these ideas were out there. I can say this because I am LDS, no basis in the LDS faith. Just you said it in your phone calls to her. So anyway, that's kind of where we're at. And we, again, we're just really grateful for you coming in. And it's going to be hard to talk about these things. And Summer Shiflett says, oh yeah.
So between Summer Shiflett and Robert Wood's statement, you put an analysis that says bias acquiescence. Would you elaborate on that analysis?
Well, the acquiescence is at the beginning of what I just read, and it's basically Summer Shiflett going, well, on balance, now that I've heard you, well, she knew enough to know something about what was going on. So she's agreeing with the narrative that's being presented by the prosecutor in that particular case, even though she initially is qualifying what she's saying, and that's rejected by the prosecutor.
Okay, so in your analysis where you say this illustrates prima facie influence of the witness, is that still your conclusion that this is prima facie evidence of influencing of a witness?
Absolutely.
And that this witness testimony is now reflecting influence of the prosecutor rather than untainted narrative. Is that still your opinion?
It is.
I'll object to that. Counsel's testifying.
I'm not testifying, Judge. I'm reading what Dr. Davidson has in his report, and I'm asking whether it's still his opinion as an expert in this case that the testimony of Summer Shiflett has been tainted. That's all I'm asking. And if you want me to rephrase, I'll be glad to rephrase.
I would ask you to rephrase then, Mr.
Right. Based on the previous narrative that you read, was Summer Shiflett's testimony potentially tainted by this technique?
Yes.
All right. Let's move on to the rest of your analysis on page 12 of the report. And we'll refer to top of page 12 where it says bias similar to me. Could you offer your opinion on that, or offer your review of that particular provision?
Well, what I'm responding to here is the prosecutor's statements that what occurred is outside of LDS, I would presume outside of LDS teachings or practices in his narrative, and that what has taken place from a religious aspect is something that, as a person who's knowledgeable about LDS, is just outside their faith and outside of their beliefs. And so in this case, where we have similar to me, we have the witness having to make the decision. Well, now who do I go with? I'm hearing not only that he's LDS, but he's also now speaking authoritatively about the LDS faith and its practices, and that this did not take place within those practices. So do I agree? Do I disagree? Why are we even talking about this? We have here a dimension that's been added that serves no other purpose except to either create some sort of bond with the prosecutor or to create some sort of bunny trail down a religious path in terms of what the testimony might be.
So in essence, influencing our testimony.
Potentially, yes.
Okay, let's start again with Summer Shiflett, the middle to top of page 24. And if you would go over that analysis after you've read Ms. Shiflett and Mr. Wood.
So I have, oh yeah, from Summer Shiflett, Robert Wood, we know that, and they're going to be nice, because obviously, you're not a person of interest. Keep going.
Oh, well, let's talk about the explanation and the best practices as in regards to the explanation.
Okay. Well, this is a part of the report that I think I made clear I don't have information on. Clearly, the recording started after some period of time, and whether that's 30 seconds or 10 minutes or an hour, I don't know how much took place prior to the narrative that I have in the transcript. So here, just in terms of explanation, in this 18 minutes, there is no explanation saying you are not a person of interest. What you have to say here, we're just looking at as a recipient witness. You're not under investigation for anything.
Okay. So I'm going to move around and move down to skipping your analysis on the middle of 24 and go to the Summer Shiflett. Okay, I'll do my best, I mean. And if you would start there.
Okay, and that's towards the bottom of 12.
Yes.
Summer Shiflett. Okay, I'll do my best, I mean. Robert Wood. It won't be easy. I know it's going to be a hard interview. Summer Shiflett, I was wondering if you would be willing to tell me, if you're able to tell me, if there's any progress in what you know about Tylee and her death. Is there any progress in her autopsy where you understand better? And then Robert Wood says, all I can tell. Well, Summer Shiflett says, I mean, do you have a cause yet, or is it close to one? And Robert Wood says, she is at the FBI state-of-the-art crime lab. Unfortunately, there's a lot of deceased bodies there that they're going through. Summer Shiflett says, I'm sure. And Robert Wood says, and so we're not. We don't know really any more yet. We may never know due to the destruction of that body. And yeah, we hope we'll find out. We may not, but obviously we know it's her. There was soft tissue that was still preserved enough to do DNA tests.
Okay. And what is your analysis of that provision?
Well, we have several things. We now have a sense from the witness that she's able to approach the prosecutor as part of the inner circle now to ask the prosecutor information about the case. Now, again, we're now in a flipped position. Initially, apparently, she was in town to answer questions about her knowledge about anything relevant to the case. Instead, now the prosecutor is being questioned and being asked about knowledge about the death of the children. And the prosecutor gives her information. Again, I don't know if this information is in the public domain, but I doubt if it was at that point in time. And I'll take that back. That's just my speculation. All I know is he provides her with information that is investigatory. And as a witness, knowing that information prior to her providing answers to her interview, to me is potentially highly prejudicial. It's going into an interview situation where now you've discovered potentially some additional information that may change your perception, your view, and even what you want to say because of what you've learned. So this is an example of really flagrant inner circle bias. The appropriate thing to have been done would be to say, I can't discuss this with you. It's an ongoing investigation.
Okay. And then if we could start with the middle of page 13 where it says Summer Shiflett and go through that narrative.
Summer Shiflett, yeah. Thanks that you guys found them like we wouldn't have ever known. Garrett, yeah. Summer Shiflett, and I would have never dreamed that she would ever hurt them so. Robert Wood, you know what? And everyone says that. Summer Shiflett, yeah. Robert Wood, that's what everyone says. Everyone says that I never would have. So it's a tragic thing. Summer Shiflett, it really is, yeah. Robert Wood, but I just want you to know how grateful we are. I know you don't have to talk to us. And so we're just grateful that you're willing to and helping us that way. And it's, I'm sure, kind of difficult knowing that they're asking for information that's going to help them in their case against your sister. But I guess the thing I want you to know is our whole goal is just justice for these kids.
And your analysis of that provision?
Well, offering thanks for coming, I think, is perfectly appropriate, and I have no problem with that. But the problem, and furthermore, saying that you may have a tough interview with the police and so forth, I mean, that's fine. Although I think it might actually increase somebody's anxiety more than empathy. But the concerning part about here is that all we want to do is we just want to have justice for the kids is paired with they're going to be asking you for information to help in the case against your sister. So we have here an anchor point being tossed out there that says, look, we're looking for information to use against your sister. Again, if we go back to best practices, we're looking to get information, and then we're going to assess what that information does and says to us. And then we're going to determine what we're going to do with it. Not, we're going to tell you in advance, we're trying to get information against your sister. Hint, hint, you're in the inner circle. We're LDS here. You've already heard the theory of the case. You've already agreed to different things that I've said in terms of acquiescence. And so I do have a problem with that narrative, just very flagrantly setting the stage for the expectations of what would take place.
Okay. And then if we could go on and talk about the rest of the statements that are made on page 14 of the report, starting with Robert Wood.
Sure. It starts off at the top after the bottom of 13 where Summer Shiflett says, yeah, an acquiescence statement. Robert Wood, and our hope is it comes to it. Your sister's actually made some overtures. She might be willing to talk to us. Summer Shiflett, I hope she does. I pray for that all the time. Robert Wood, we hope she does. She actually was talking about with Chad about talking with us before we found the bodies, just a few days before, and he talked her out of it. Continue.
Well, what's the analysis in that provision?
Well, the analysis is the best practices deal where rather than try to get the witness's comments about her viewpoint on anything, he again is providing information about the case. And that information is going to do nothing helpful in the interview of the witness for her interview to be just a uncluttered, an unimpacted narrative of whatever she had to say to the police.
So in other words, your analysis is that the likelihood is that discussion with Ms. Shiflett is going to have an impact on Summer Shiflett's testimony with the police.
I think it's very likely. That is a strong concern.
Okay. And when you say a strong concern, would you elaborate a little bit on that for me, please?
Well, it's a concern that she's hearing repeatedly expectations about how this case is going to unfold. She's getting questions answered and given information that is not privy to the general public. It is a concern because that information is going to be in her head when she is asked investigatory questions by the police following this 18 minutes and whatever preceded it. We don't have a situation that really is a level playing field with a sterile set of questions being asked. We have preceding questions and instruction that is going to potentially and likely affect her responding.
Okay, and when you talk about a level playing field, what you're talking about is two sides of a particular case, i.e. the defense and the prosecution having a fair opportunity with a witness. Is that what you're referring to?
Your Honor, I'll object. Counsel's testifying.
I'll withdraw that, Judge, and I'll move on. Would you then go with Summer Shiflett at the top of the middle to top of page 14 and review the statements in that going through and through page 15?
All right.
Summer Shiflett, sorry.
Here, before I have you just read that in, we've already got in the record the transcript. We've heard the call as well. It's also in your report. So this is very cumulative to just read it verbatim into the record. If you want to review those, I will review them as well and listen to the analysis. If there's something in particular you think should be highlighted, Mr. Pryor, we can do that. But I don't think it's necessary to just verbatim read this transcript again when it's already been submitted in the hearing.
Okay, well, I guess I wanted to put some perspective on exactly what the analysis is with regards to each provision. And I guess my thought process, Judge, was simply without knowing what provisions we were talking about, it's difficult for Dr. Davidson to offer his analysis on each of the provisions. But if
I understand that, and I can read it. It's here before me also. I'm just trying to save my court reporter some grief getting through this hearing too, when we already do have the very record of what's being read.
Well, Judge, I mean, at this time, if you would like to take a lunch recess, I'll defer to the court's wisdom, or if you would like me to go on, I'll try to move through this much quicker.
Well, I thought maybe we could get through your direct with Mr. Davidson and then take a break before we go to the cross-examination. So if you want to continue plowing along, we'll do that for now.
Okay.
Thank you.
So Dr. Davidson, proceeding or starting on page 14 through 15, there's some discussion between Mr. Wood and Summer Shiflett, and you put in a reference saying bias acquiescence. Given the fact that the court would prefer not to have each of the provisions read, can you give me in some detail what you mean by that bias acquiescence on page 15 of your report?
Yes, and I'm just glancing at that section really quickly.
Okay.
Well, basically, there's a narrative here that takes place with the prosecutor. And in the narrative, Summer Shiflett agrees with the comments that the prosecutor makes. So she's not being questioned, she's being talked to and informed. And the acquiescence is she's just now agreeing again, basically with everything that is being said. So the acquiescence is an indication that a person is on board, that they are now in the in-group, that they have decided where they're going to cast their allegiance by and large. And that is potentially an indicator of testimony later that will be influenced.
Okay, now on the bottom of page 14, there's a provision, and it's 5 comments down, and it starts with Mr. Wood. Well, do you see that comment in your report?
I do.
Would you read that for me really quickly?
Robert Wood. Well, I'm the visionary guy, so you know, Davidson is the visionary guy. So, So anyway, again, I just wanted to meet with you real quick and introduce myself and Mackenzie. She's.
Okay. Now, his comment that I just wanted to meet with you really quick. In your opinion, is an 18 to 20 minute narrative a real quick meeting?
I think it depends on what the content would be. I could conceive of it as a quick meeting if it was a meet and greet without getting into the theory of the case and so forth. But I would think typically, because the day is set out for an interview by the police and presumably they're waiting or there's an appointment time, 5, 6, 7, 8 minutes. Glad to meet you. Glad you're in town. Hope things go well today. Just wanted to introduce myself. Would be more than enough time.
Okay. And then if you would be so kind, in the middle of page 15, review the statements that were made on the tape, and then let me know when you're ready.
Are you referring
Just
to?
Not read them out loud, just review them quietly to yourself.
I understand, but are you referring to the top of 15 to the
middle of 15? The middle of 15.
Down. Got it. Thank you. Okay.
Okay, now in the middle of 15, there's some reference by Mr. Wood suggesting that Mr. Means is incompetent and that he doesn't know what he's doing. You have analysis at the bottom of your report on page 15 that says bias derogation. Would you please elaborate on that for me?
Well, sure. In this particular case, there's really no purpose and no reason, if we're trying to get the witness's testimony, to have any discussion about any of the other attorneys or parties or players in this case. And so in this case, where the defense attorney is mentioned as incompetent, no experience, lying about the prosecutor, and that he basically will be recused from being a defense attorney when additional charges are filed, all really derogate both his reputation as well as his influence. Because he's inevitably going to be discharged, his influence is ultimately zero. He doesn't know what he's doing, so actually his influence could be negative. And furthermore, he's just a liar. So when we have all of this information, as in terms of derogation, in terms of influencing a witness, first of all, it'd be very daunting to challenge somebody who is saying this about opposing counsel. It would take a pretty gutsy witness to go like, well, hey, wait just a doggone minute. I don't think that's fair or that's accurate, especially when we know the stakes that are involved in this particular case. And so the derogation really serves a function to minimize the credibility, in my opinion, of the defense, and to further solidify, you're in my group, you're in the in group, we are LDS. I've told you information about the case. You know more than the average person. By the way, we don't want to go any farther than this. We have to, and it's really Chad. She knows, but it's mostly him. We have here, a continued pattern that's expanded now very flagrantly with the comments about the defense attorney. Okay,
and this is a flagrant display, is it not?
I've done this for years. I've never seen anything like this.
Okay. If you would go on with your review of the top of page 16, I believe there's 3 sections that I'd like you to review, and then describe your analysis of the inner circle bias that you relayed in your report, sir.
Right. So he's thanking the witness for coming in, which is fine, but the witness is then saying how weird this is to be speaking for the prosecution and speaking for the defense, and how she's torn. And that's a relevant comment to me, because the issue wouldn't be at all how she's torn. The issue should be, what evidence does she have to offer through testimony? That she may be torn is something that people could always discuss, I suppose, at a different point in time. But for her to bring it up is suggesting to me this conversation has prompted and promoted her feeling torn. She came in and has made some positive statements about her sister earlier in the narrative that were not followed up on or regarded. And now she's pointing out, I'm between a rock and a hard place. I'm on the horns of a dilemma. It's weird to be dealing with both sides in this. So the inner circle bias that comes out of this is, where are you going to land? How are you going to reconcile that? Whose side ultimately are you going to likely be on? Again, if this is an interview situation, ultimately, that's the reason she's here. There shouldn't be a side to land on at all. There should simply be her unfettered testimony.
Okay, so your comment, the prosecutor's statement, an effort to influence the witness, has caused cognitive dissonance. Please explain to me what you meant by that statement in your report of these statements that Mr. Wood had made.
Right. Cognitive dissonance is just a $5 way of trying to say, I'm feeling pressure on two different dimensions that are really causing me to struggle. And that's what she points out. Prosecutor, defense. Where do I go with this? The dissonance is the confusion that stirs up mentally. What should I do with this? How do I reconcile this? How do I handle this? If I'm asked a question and it draws on me to be loyal to my sister or to her defense, what do I do, having heard the theory of the case and the prospects and the information from the prosecutor? There's no reason a witness whose information is simply trying to be garnered should ever be put in the position of having to have that kind of internal battle. They should just be asked, what do they have to say? Not what do they have to decide to impact what they may say.
Okay. If you would be so kind as to read the rest of the narrative on page 16, and then discuss your findings on the top of page 17. And you could read it to yourself.
I am. Okay, so I'm ready.
And if you would provide us with some interpretation of your analysis in regards to the statements on page 16.
Well, what's happening here is, speaking just a moment ago about cognitive dissonance or being on the horns of a dilemma, prosecutor versus defense. She elaborates on that a little bit for a few lines, but then she now is comfortable enough to ask about whether or not there's going to have placed on the table the death penalty. Is this going to be a case where that will be something that will be thought, I believe. Let me check real quick. Yeah, so she asked whether there's going to be the death penalty, a capital charge. And again, that's reflecting she is extremely comfortable now with being in the inner circle of the prosecutor, because she's asking the person who's going to be responsible for making that capital charge if it does come about. And as far as being on the horns of a dilemma, we see a conversation about that. And we also would have to understand, this is my sister. Now, what do I do? How do I handle this being, and you take all the preceding information, being LDS, being this, being that, what do I do in trying to reconcile this? And how will this affect what I have to say when I am interrogated later today? Questions.
Okay. And then if you would be so kind as to review page 17 and then offer your evaluate or your findings on the top of page 18.
All right, so what we have here is a couple of biases that are concerns. One is the mutual activity, again, the refinement and the defining of what that means as our purpose. The purpose has been expanded by the witness who's comfortable enough to ask about the death penalty, but she gets a response instead of that's something I can't discuss. or we'll have to determine that later. So she does get a response, and she's informed that that's something that he really doesn't want to do, and alludes to how if there was really the ability to have perhaps a plea deal, you know, in a capital case in general, that would be life without parole. There's an allusion to that. So now we have the witness who actually has a little bit of power. You know, what can she potentially do to influence her sister if she talks to her on the phone? Because about this potential capital charge, he doesn't want to do it, but and so we have insight into something that typically you wouldn't hear outside the prosecutor's office. You know, they're charging decisions and they're charging contemplation. So that's a mutual activity issue, defining that our mutual activity apparently is to not just have you tell us what you know as a witness, but now we can go to the extent of determining what do you know about how they died? Are you going to bring up the death penalty for capital charges? This has become a very, very odd meet and greet prior to being interviewed. And then there's the inner circle bias, because she is a member of the in-group. She can go ahead and ask these really high value questions. Are you going to charge my sister with capital murder?
Okay, now you made some reference in your report on page 16, and I'll go back to that ever so briefly. And you said that, well, I may have that incorrect. In your report, you had referenced the fact that she now becomes a member of Mr. Wood's inner circle. Is that your assessment of what the provisions were referring to?
Right. That's part of what I just mentioned as being part of the inner circle. You know, now we really see pretty strong evidence that she has adopted that viewpoint. She is part of the inner circle. She's asking case-specific information, including charging information, and she's getting answers.
So specifically what you're saying, and please correct me if I'm wrong, at this point, this witness has adopted the prosecutor's theory of this case.
I don't know to what extent, but she is acquiescing to what he has to say. She's comfortable enough as part of the in-group to ask these kinds of questions. It certainly would appear to me that she is influenced strongly by the information she's heard and the questions asked.
Well, let's go on to read to yourself page 18. Actually, you know what? I think, yes, let's read page 18, and then we'll talk about your findings on the top of page 19 when you're ready.
Okay, give me a second. Okay, I'm ready.
Go ahead.
We have a bias about religion because it's being said to her very clearly that, you know, he's the one that really is the religious influencer in all of this, as well as how his views on theology and Latter-day Saint beliefs manipulated Miss Vallow. So we have a shifting of responsibility to Chad Daybell, part of the theory of the case, maybe a sigh of relief to the sister in her testimony. And from that standpoint, the religious aspect becomes a piece of the overall judicial picture, where it doesn't make any sense to have it be a piece at all. And certainly doesn't make any sense, and this is the next bias in terms of inner circle, to have the prosecutor pass on further his theory of the case that the main culprit in this is Chad Daybell. And it came about partly because of religious reasons and so forth. So we're way beyond, again, just you're in town for an interview.
Okay. And then what you did is you made a number of findings, and I'm not going to have you go over those. The report speaks for itself about those particular findings. What I do want to do is go to your conclusion page on page 22.
Okay.
Let's start with acting ethically, the American Bar Association.
Well, there's going to be model rules of professional conduct for the ABA, and I simply noted in my report, I'm not an attorney, I'm an associate member for what it's worth, but I had no basis to make any comments about prosecutorial conduct related to the ABA model rules of professional conduct. It's outside the scope of my capability.
Okay, acting with integrity, and you're talking about Idaho Criminal Code 182604 sub 3, which is talking about it's a crime to influence or coerce a witness. What did you include that in your report for?
Well, I included that because the efforts in this 18 minutes, to me, adversely affect the concept of free, full, and truthful testimony. Now, maybe not truthful, but certainly free and full. And so I'm simply suggesting, from my opinion as a forensic psychologist, that there was improper influence of the witness in this case by the prosecutor.
So your comment under acting with integrity on page 22 of the 24-page report is that the efforts of the prosecutor in the interview that I analyzed suggested improper influence of the witness. Is that still your finding?
Yes.
Okay. Avoiding, the next section is avoiding inappropriate interviewer behavior. Would you provide us your analysis on that conclusion?
Let me glance real quick. Sure. So here, very straightforwardly, greeting a person, asking open-ended questions and so forth. In terms of interview behavior, we really don't have an interview. It's a simple process. We don't have anything asked beyond one question about Chad Daybell. So the efforts that I see in this narrative have nothing to do with an interview of a witness brought into town to be interviewed. They have to do with influencing that witness, period.
Okay. And then I want to go down to the middle of page 23 of your report, where it says the witness is a vulnerable witness, and then provide your analysis of that provision.
Okay. Well, the witness is a vulnerable witness because of her relationship to the defendant. She's her sister. And to that end, anyone would acknowledge that that's an emotional relationship of one dimension or another, to the point that she has asked the prosecutor about whether or not capital charges will be brought. So a vulnerable witness, a person who emotionally is highly involved in a situation, is a person that really needs to have the utmost professionalism in their questioning and in their treatment and in their handling. And the reason is because their vulnerability makes them more susceptible than the average person to having their comments be suppressed, influenced, be exaggerated. You can go in whatever direction. It's going to vary according to the person. But that's why I raised a concern about her as a vulnerable witness, because I believe she is one.
Okay, and then the next paragraph, the interview with the prosecutor provides the witness, and if you would elaborate on that conclusion.
Well, I think that the thing here we have is really kind of fencing in the witness in terms of what's okay to believe and who she should align with and what's not. So we have it be known that the defendant's manipulative, he's wimpy, he's outside of LDS doctrine. He is a person that probably is the main bad actor in all of this, which may or may not influence what she would say about her sister, but you would think that it would, because if he's really the bad actor, then you don't have much to lose by saying whatever you care to about this sister, especially since the prosecutor does not want to bring capital charges and would prefer to have this case be somehow settled, perhaps. And then we have from there the defense attorney's malignment, really, again, putting a fence in, going like, hey, whatever's going on that side, it's not going to last, not going to be there. He's lying, he's incompetent. So don't pay any attention to that. I've answered your questions. I have cooperated with you. I've told you what's going on. I'm your ticket.
Okay, and then the next paragraph says the prosecutor specifically asked the witness to consider various aspects. And if you would elaborate on your conclusion in that paragraph.
Well, in various times, I want you to consider, I want you to suggest, thinking about, I'm paraphrasing a little bit liberally here, but she is really asked to consider and told the theory of the case. And so when that occurs, it basically, in my world, in forensic psychology, you consider that coaching. I'm going to tell you what I think is accurate. You're agreeing with me. I have acquiescence. Let's keep going. Well, I answer your question. Now you're in the in group. So the impact of all of this is to, again, go back to the concept of co-opting. We're bringing that person into the circle. And now that person is highly vulnerable to providing information that will be favorable to the prosecution and not to the defense, in the sense that it may not be brought up, it may not be answered fully, it may be suppressed, who knows. But the impact of all of this is not neutral, and it certainly is not favorable to the defense. It is adverse to any defense, and it is favorable to the prosecutorial position.
Okay, and if you would be so kind, and this will be my last question, would you read the last paragraph of your report for me, sir?
It strains credulity to think that the efforts of the prosecution had no impact on the subsequent testimony of the witness. It is apparent during the interview that she seeks to please the prosecutor with her responses and begins to volunteer information in an apparent effort to help him. It is likely that the subsequent interview of the witness has been influenced and tainted by the nature of the initial interview with the prosecutor.
So is it your position then that this witness has been influenced by Mr. Wood's conduct during that 18-minute discussion?
It is.
All right, Judge, I have no further questions.
Prior, well, let's take our lunch break at this time. We are starting late, but we'll do a 1-hour lunch break. So we will be back on the record at 1:40 p.m. Does that give everyone sufficient time to do what they need to do during the break?
Yes, Your Honor.
Yes.
All right, thanks. We'll see you all back in an hour. Mr. Davidson will continue with your testimony after that. Thank you. Or Dr. Davidson, I should say.
Thank you, Your Honor.
Kendall, are you there?
Yes, we are live streaming still, and Doug will put up the message.
Oh, okay, sorry.
Are you guys there? Can you hear me? Can you hear me though? Let me know if you could hear me, because I think I am gonna, yeah, you could hear me. I think I'm gonna go, depending on how, I might pick it back up. I don't know. The only thing is this, Idaho is 2 hours behind me. So this possibly could go on to 6 or 7 tonight, and I can't, I have to get ready for my my interview. So, man, I did not expect it to be an all day thing. And at least I expected it to be like interesting. I can't believe how they're picking apart this interview like so much. Hello, it's a prosecutor interviewing a witness. Of course there's motive behind it. They're not just hanging out because they're friends. I mean, there's a motive behind it. Duh. I mean, they're not hanging out because they want to. It's for a purpose. I mean, it just doesn't make any sense. This makes no sense to me. I think he'll win. I really do. But you know what? Like Misbehave said, if he doesn't, well, I hate to say oh well, because that's his life, and that would suck for him, because that's his life and his job. But as far as for the case, it probably would be okay. You know, there's just as good prosecutors, if not better, so it'll be all right either way. But it would suck for him though, because that'll go against him. You know, I don't know how that looks on your job. Like, I don't know how that would look on his whatever, trying to, well, he's a prosecutor, so I don't know if he would necessarily have trouble. Yeah, he'd be all right. He already has a job, but it just would suck for his reputation, I guess. Even though we all of us agree, like, I don't feel, I want to hear that Zulema interview, because that's one that I haven't heard yet. As far as the summer interview, I saw absolutely nothing wrong with what he did. The one big point that they kept talking about is the death penalty. Well, she freaking asked him. So that whole point was stupid. I mean, they have no point then. She asked him, what's he supposed to say? Ignore her? He answered her question. And then she even said that, do you remember? She said, oh, well, Lori probably would rather probably have the death penalty or something. I don't know her exact words, but basically saying that Lori might prefer and might not be upset if she did get the death penalty because, you know, she's just because of everything, you know? So, yeah, I don't know. It's stupid. Okay, so I'm gonna hang out with Zeke a little bit because my grandma's in the shower now, and Zeke's all by himself. Zeke, come here, buddy. Come here, buddy. Where are you at? I was hanging out with him on the couch down there. All right, so I'm going to get going. Maybe I'll post like the end of it or something in a short video, but I doubt I seriously doubt I'm going to come and live stream the rest of it. Zeke, come here. Live stream the rest of it if it's going to be like another 4 hours. But maybe I'll just post the end of it for everybody. And yeah, I'll see you tonight, guys. I'm going to post that in the community post right now. My interview with Sherilyn at about 8:30 Eastern time. Come on over and check it out. It'll be interesting. Jill, the private investigator, is going to be up there with me. So hope to see y'all there. Have a good day, everybody.